May I have my lord kindly mention one non-prosecution and one stay application, my lord?
Yes, yes. Give.
I'm grateful, my lord.
I mentioned one Jalpaiguri matter is not Jalpaiguri is not zero. And there's a, I am
No, what is the urgency?
and this stay petition. Your Lordship.
So very well, it will sit from Monday. You mentioned on Monday before the bench.
15. On 15.
15.
We are in today. We are
No.
Monday not coming.
15.
Yes.
That's why you
No,
know
what is the urgency?
stay petition is to be moved, Your Lordship. The appeal has already been filed in Jalpaiguri bench.
No, appeal is filed. But what is the urgency now? You can wait for 7 days. Just a matter of 7 days.
Your Lordship already knows. In this type of matters, attachment order comes in after 90 days. In this 90 days, the judgment is of dated 22nd of August.
No, when is the next date fixed before the executing court?
Your Lordship, that I have to I just today I am humbly praying for the leave for filing the stay petition and nothing else, Your Lordship, and I will move the mentioning notice tomorrow.
No, you just ascertain when is the execution case fixed, obtain a copy, thereafter mention tomorrow or on Monday.
This is an application for stay application, my lord.
Yes.
Section 5 application in the state of plenty.
Yes. Give it. Applications, yes.
My lord, mentioning a matter for inclusion in the list.
For application?
Yes, my lord.
Application, yes.
Lordship, I would have mentioned it anyway. Lordship, what fell from Lordship on the last occasion.
Let it appear tomorrow has to be mentioned.
Lordship, let it appear. I will be praying that subject to what.
Let it appear tomorrow
Very
to
well.
be mentioned.
I'm grateful.
Yes, call the list.
Item number 1 and 2.
My lord, item number 1, I am one matter, this is my appeal, that is one. I am for the appellant, my lord. Another matter is appellant is Purimal Pahari, my lord. These, both the matter are ready. Your
No, item number 1, you are for the appellant.
appellant,
Appellant Clement.
claimant.
Okay. So what is this application? Can 3?
Can see, this is not, can see, my lord, already substitution application filed and it was allowed, my lord.
So this
Can-
matter is ready for hearing.
Yes, my lord, ready.
Let
for
it
hearing.
appear in the month of January. Prior to that, you take a chance before the Lok Adalat. It will be held in the month of December. I'm keeping it in the month of January. Prior to that, let it be placed before the Lok Adalat. Item number 1 and 2, both of it.
To my Mr. Purimal Pahari on behalf of the appellant,
Anyway, I'm sending these analogous matters.
my lord.
Yes, record an order.
If not Lok Adalat,
Yes, then it will be taken up in the month of January.
January.
Learned advocates for the appellant is present. As
This
these matters relate to motor accident claims and there is a chance of settlement, the matter is referred to the National Lok Adalat to be held in the month of December. Let this matter appear on 12/1/2025 for report of the National Lok Adalat and further orders. Both 1 and 2.
Item number 3.
Yes, Mr.
I'm happy on behalf of the respondent. Filed by the petitioner on the ground.
No, this is you are for the respondent. You are for the appellant.
Petitioner.
Item 3.
Appeal. I am for the respondent. Very simple point. I will have to indicate the point. Before opening, may I answer?
That is, you are representing the Union of India.
No, I am representing.
FMA 664.
664. Resmi metallics. I am appearing.
Okay, you are for the appellant.
I am for the respondent.
Yes, matter is ready for hearing.
Point, very simple point. I am entitled to an exemption. Exemption granted at a particular date. One fine morning, they say you have to furnish this document. I furnished that, time expired. The following day, it was, I should say, reimposed that exemption. In the interregnum, one transaction was there for 2 days. That has been charged in the higher.
Anyway, matter is ready for hearing. Paper books have been filed.
No, I've not got, I've not received repeat paper.
You have not received.
No, you have the respondents. You have filed the paper books.
Yes. So,
So
filed. আছে তো আপনাদের কাছে? আনাও, আনি নাও। Department.
Matter is not ready.
yes, record an order.
Oh, last occasion the paper book was here, maybe here.
Yes, record an order.
Paper book আছে?
Learned advocates for the parties are present. It is submitted by the learned advocates that the matter is ready for hearing and the paper books have been filed. Let this matter appear for hearing on.
This is the point, very short point.
Yes. Appear for hearing on. আচ্ছা 6 তারিখে দেখুন তো দুটোর সময় কিছু ফিক্স ম্যাটার আছে কিনা in the month of January.
Oh, I am thinking of this 6th.
Only 1 week I'll be sitting. The last 2 weeks I'll not sit.
It will take 5 minutes, any day sits, my lord.
Whatever it is, you see, there are so many matters.
It's not pressure.
Any-
Pressure.
না দুটোর সময় কি তিনটের সময় কোনো ফিক্স ম্যাটার আছে তিনটের সময় 6 তারিখে
January.
Okay, 6/1/2026 at 3 p.m.
Oh, 6th.
6/1.
Oh. One part hard matter is fixed
Okay.
by the division.
আচ্ছা 7 তারিখে দেখুন তো কিছু আছে কিনা দুটোর সময়
7 তারিখে কিছু নেই।
7th.
Okay, 7/1/2026 at 2 p.m.
যদি না পা চিঠি লেগে আমাকে
না, ঠিক আছে।
কবে দেবে?
Very good. Item number 4.
So, number 4, kindly see the judgment. There's some typographical mistake, Lordship, kindly see
When it is disposed,
disposed of. Lordship, kindly see the
which page?
before last page.
Okay, before last page.
Yes, while Lordship was directed,
Page 6, yes.
while Lordship was directed in second paragraph,
Yes, this appeal stands disposed of.
Lordship, kindly page 6, second paragraph.
Yes.
The balance amount 44,000, Lordship, found. And along with interest from the date of filing till the date of evidence, Lordship, should be till the date of realization. Because of that amount, Lordship is enhanced.
No, question is submitted have already received the award sum as directed code. The balance amount of 44,000
Yes,
from the date of filing till the date of realization.
Lordship. Only this is the mistake.
Yes, record an order. Learned advocates for the parties are present. This matter is put up for necessary rectification in the order dated 26/11/2025. There was a direction upon the opposite party respondent number 1, National Insurance Company Limited, to deposit rupees 24,000 along with interest from the date of filing till date of evidence. Stop. Instead of date of evidence, it should be till the date of the order passed by the appeal court. That is 26/11/2025.
Not date of order.
Yes, date of disposal of this appeal from the date of filing.
Date of deposit.
In other matters also I have directed. Okay, date of passing of this order, that is 26/11/2025. Stop. Other contents of the order.
Also another is just
Yes.
first line of that page, space 6. This is MSC case number 31 of 2018.
Yes.
Yes, that should be. Lordship, kindly see, it is the initial issue file 14 of 2015. So by slash that number, it is a renumber. It was filed on
No,
2015.
Whatever is there as per the order, okay, that I have stated.
That part is
No,
not in the
whatever
order.
there is in the award, okay, that
yes.
has to be reflected.
Lordship, kindly, otherwise they will calculate from the date of 18. Otherwise, I have to come before you, Lordship, further. Kindly one line add, kindly.
No, whatever is, you see, it is stated. Acha, and it is clarified that the date of filing
The case institute,
filing in the of this claim case will mean and include the date and filing of the case originally instituted
is on
and numbered as MSC
14 of 2015.
MSC case number 14 of
2015.
2015.
It filed on 19th.
Whatever it is, that will be. Other contents of the order remain unaltered.
Five. Worship, I am appearing on behalf of the appellant. I lead by Mr. Sanjay Mukherjee. He was engaging in court number 16.
So this is whose application? Can one?
Can one is my application.
You are for the respondent. Can one is for what?
Stay of the judge.
Without notice, my lord, last time.
Yes.
Without notice, my lord,
Okay, not this week.
Lordship fixed a accommodation.
Monday it will be taken up.
There was a direction for Tolowana has not been filed.
Yes.
There was
Tolobana is not yet in file. That is.
Okay, let it be filed.
Yes.
I'm just making it not this week. Okay.
Get.
Number 7.
Number 7 ডাকলেন তো? I am for the appellant. This is a railway appeal, my lord. I am seeking direction for the lower court, call for the lower court records and informal paper book. On the earlier occasion, delay was allowed by the Honorable Justice Bandyopadhyay.
So you are for the appellant.
Yes.
You are for the respondent.
My lord.
So let the paper books be filed.
Lord, I am waiting for hearing of section 5 because there is delay of 200 days.
No. Section 5 is disposed.
Disposed. This is the order.
You have the order.
Yes. Yes. On
Show
the
it to your learned friend.
Sujoy Sinha. This is Sulata Kanji and Union of India. Sulata Kanji too. Order dated, my lord, 22/9/2025.
So the matter has to be heard out after receipt of the trial court records.
With the help of special
Let them
messenger
file
cost.
paper book in the debate.
Yes, after the records come. Learned advocates for the parties are present. As the trial court's records have not come, let the trial court's
With the help of special
records
messenger.
be called for. Stop. The trial court's records be called with the special messenger cost to be paid by the appellant. Upon arrival of the trial court's records, the appellant shall take steps to file the paper books. And the trial court's records along with this record shall be sent down to the department for filing of the paper books.
Respondent.
The paper books shall be filed on or before 16/1/2026. Let this matter appear on 19/1/2026.
19/1 will appear.
19/1/2026.
Grateful to your lordship.
জানি না কবে হলো।
Yes, item number 8, I am for the appellant, Your Honor.
My lord, in this matter, I appear for the respondent.
Yes.
My lord, earlier occasion, that is on 22/9/2025.
আমাকে একটু বলতে দিন, আমি তো দাঁড়াচ্ছি, বলে দিন একটু।
No, the matter is ready for hearing.
No, this earlier occasion delay was disposed of and the same direction, my lord. Informal paper book and LCR.
So same order can be passed?
Yes, Your Honor.
My lord, in addition,
In addition.
what is my prayer? My lord, kindly see that in that order, I appeared on behalf of railways. But kindly see the order. The learned advocates represented the appellant's claimants is present. None appears to represent the respondent. But at the very beginning, so and so for the respondent.
So if you want some correction, you move before the bench which has passed that order.
Yes, I mentioned before there, and they refer the matters before your lordship. I mentioned before court room number 33.
No, why? Do you have that order?
There was yes, I have the order.
No. Question is that this matter to be taken up by this bench, regular bench. Is there any order?
No, order was not there.
So it would be better to make necessary corrections by the court. Yes, if there is an order that the matter be placed before the regular bench for correction, I'll definitely take it up.
I mentioned that is my lord's pleasure.
You get that order, okay? I'll take it up.
My lord, it is very difficult. My lord, you do whatever my lord's.
No. I am not passing any order with regard to that, okay?
But record my name at least.
Today.
Today also recorded.
Acha, just 1 minute. Acha. Same order as the previous, as this one. Which was the other number?
Other case,
Yes.
item number 8, FMET IR 4 of 2024, my lord.
No. This is your present case. This is 9.
No,
So this
8.
is 8.
Item number 8.
The other case also.
Other case was 7.
other 7, ঠিক
Yes,
আছে?
my lord.
ওই 7 এ যে অর্ডারটা হলো সেই অর্ডারটাই পাস করাবেন, ঠিক আছে? আচ্ছা, in addition to that, learned advocates appearing for the respondent Union of India,
No, railways.
respondent railway authorities
Yeah.
praised for necessary rectification of an order passed by another bench of this honorable court. Stop. So thus the said correction may be thus the learned advocate may move the said learned bench for necessary corrections. So I made it clear in this order that you want some correction, let it be moved before that bench.
Lordship, the same date, 16/1.
Yes, the same date.
Grateful to your lordship.
Yes, the next date is 19/1.
19/1 and 16/1/26. Before that, paper book has to be filed.
Yes, 19/1
Yes.
will be the next date.
এই দুটো slip রেখে দেবেন। Grateful to your lordship.
Fine. Milord, here, Milord, I appear for the respondent railway, Milord. And Milord, in this matter, Milord, the
Yes, you are appearing.
No. Mr. Nobin Mittal is there. He is out of station. He told me that.
Let it be not this week.
here, Milord,
Yes.
what I submit, Milord, the claim has not been proved by evidence.
Yes.
Milord, here the may be sent for the Milord, this Lok Adalat, Milord.
But I can do that. But you see, I can do that. But you see, the other side is not here. That is the difficulty. Anyway, record an order. Learned advocate for the respondent railway authority is present. As this matter relates to railway claim and is submitted by the learned advocate for the railway authority that it may be settled, the matter is sent to the National Lok Adalat to be held in the month of December. Fix 12/1/2026 for report of the National Lok Adalat.
National Lok.
Yes, that is in the month of December. You intimate the other side advocate.
Milord, this is in December itself.
Yes.
In the month of December.
Yes.
Grateful to your lordship.
Number 10.
10 is the appeal of insurance company. Pursuant to the directions of this honorable court, Milord, the awarded amount has been secured. Paper book is prepared. Milord, a very short point was involved in this case. Milord, it was on the quantum. This appeal was on quantum.
Same case, let it go to Lok Adalat and thereafter you come.
No, Milord, the order of my lord is required. Milord, I'll just take 1 minute of my lord's time. Milord, that deceased was a businessman, Milord. He died, Milord, in January 2020. January 2020. Milord, his last income tax return, Milord, which was filed before the court below, Milord, that was for the financial year 2017-18. When this matter was taken up by the honorable court, Milord, her ladyship, Milord, Honorable Justice Ananda Bandyopadhyay, Milord, asked, Milord, us, and Milord, I also pointed it out, Milord, on behalf of the appellant, that Milord, immediately prior to the death, the last income tax return was not filed.
Anyway, in this matter, railway authority, the government authority appeared.
Yes,
Probably there is a direction.
Milord, that was another matter.
Okay, another matter.
Milord, why I'm pointing it out to your lordship, Milord? The honorable court asked, Milord, my learned friend, to furnish the last income tax return prior to the death of the deceased, which was not filed before the court below. Milord, they have filed that income tax return before this honorable court, before the appellate court, Milord, to come to the exact figure. Because, that was not somehow or the other, they admit that they have missed it out. They filed an affidavit to that extent. Honorable Court asked them that in order to arrive at just compensation, it is the responsibility of the Honorable Court also to see to it that they get, whatever is legally due to them, So, on that basis, they filed an affidavit. They admitted that they have missed out, filing the last income tax return prior to the death of the deceased. Honorable Court took note of that, and said that, okay, on that basis, I'll dispose of this appeal, taking note of the last income tax return and that net income. So, affidavit is here before your lordship. Not only this calculation has to be made on the basis of last income tax return, and this appeal can be disposed of. There is no other point involved in this case.
So paper books is not required.
Paper book has already been filed. Along with the paper book, one affidavit was
And
asked.
the stay order is already there.
The stay order is there. Entire amount is secured before my lord's court with interest. Amount would decrease by a slender margin. Because the last income tax return, on that basis, calculation is to be made by your lordship. Either my lord can dispose it of here and now, we'll make the calculation, or my lord tomorrow or the day after, whenever my lord pleases,
I can keep it day after tomorrow. You come with necessary calculations.
My lord will come on the day after with the necessary calculation. Day after is Saturday, perhaps your lordship wants.
No, Monday.
On Monday.
That is the next working date after Friday.
My lord, Monday.
Huh? Okay, let it be made not this week, just.
Lordship. Will come back on Monday with
Come on
necessary
Monday.
calculation.
Monday in the same heading, okay, to be mentioned.
Lordship. Obliged to your lordship. This is, the issue, is that the Honorable Court, takes it upon itself to come to the right conclusion that what is the exact amount which they are entitled. Whether, I point it out or not, but the Honorable Court says, the just compensation should be just.
Okay.
It should be unnecessary.
When it has come, the court has to consider.
Lordship. I'm extremely grateful to my lord. So, on Monday, we will come with the calculation. Item 11, is insurance appeal. Insurance company does not wish to proceed with appeal. Your lordship will kindly, dismiss it as not pressed.
Yes, record an order.
The instruction issued by the client be kept with the records.
Mr. Singh, learned advocate for the appellant, Oriental Insurance Company Limited is present. Mr. Singh submits that his client, appellant herein, is not willing to proceed with this appeal, and he has received necessary instructions in this regard. The letter issuing the instruction is filed. Stop. In the facts and circumstances, this appeal, FMAT within bracket WC 20 of 2025, stands disposed as withdrawn.
I'm extremely grateful to your lordship.
Let the instruction file be kept with the record.
Obliged, my lord.
Item 12.
Item 12 is insurance appeal. In this case also, entire awarded sum is secured before your lordship. Paper books are ready. Your lordship will fix.
Come in the month of January, let it go.
Whenever my lord pleases, whenever my lord.
No, but let it go through the Lok Adalat. Thereafter you come. Yes,
chances of settlement is remote.
You take steps, you see if there is some possibility. You ask your client. Learned advocates for the parties are present. It is submitted by the learned advocate that the matter is ready for hearing and the paper books have been filed. Stop. Thus, this matter, as this matter relates to motor accident claim and may be settled, the matter is referred to the National Lok Adalat to be held in the month of December. Fix 12/1/2026 for report of the National Lok Adalat and further orders.
12th January.
Yes, if you can see it is settled, well and good. Otherwise, I'll hear out the matter.
I shall give it a try. Grateful to your lordship. 12th January.
Item 13.
Item 13, my lord, I am filing the affidavit of service. It is railway matter, my lord. My lord, paper book order may kindly be passed. We shall prepare the paper book, and my lord,
But for the appellant, service upon the opposite party respondent is complete.
My lord, I'm filing the paper. I'm filing the.
But they have not entered appearance.
They have not entered appearance.
Yes, record an order. Learned advocate for the appellant is present. Learned advocate files affidavit of service. Let it be kept with the record. Let the trial court's records be called for. Upon arrival of the trial court records, the learned advocate for the appellant shall prepare the paper books and file the same on or before 16/1/2026
And my lord, liberty may kindly be granted, my lord, to obtain the certified copies from
Yes,
the.
yes.
LC.
Let this matter appear on 19/1/2026. The files be sent to the department along with the trial court records for obtaining certified copies of the same. The appellant shall also take steps to serve notice upon the respondent through the department.
Hmm.
So you have served personally.
Yes.
Now you serve through the department.
Yes, I will file the notice.
Yes.
Then 14.
14, my lord, I appear for the appellant insurance company, my lord. I have served, my lord, and deposited the awarded amount, my lord.
For the claimant, my lord.
To the 11.
So this is what a stay.
Yes. The stay
Oh,
may be made.
statutory amount. You have
No, final amount.
entire amount.
Entire amount. I'm handing over the challan. Let the stay be made absolute and
Yes. এটা দেখি রেকর্ডটা। Yes, record an order. Learned advocates for the parties are present as the appellant insurance company has deposited the entire awarded sum in terms of order dated 22/7/2025 passed by learned coordinate bench of this court. There shall be the judgment and award passed by the learned trial judge a judgment and award passed by learned additional district judge first track first court Islampur on 13th September 2024 shall remain stayed till disposal of this appeal. The respondent, let the trial court's records be called for. The paper books be filed by the respondent. Okay, the trial court record be called for at the special messenger cost to be paid by the respondent. Upon arrival of the trial court records, the paper books be prepared and filed on or before 16/1/2026. Let this matter appear on 20/1/2026, 28th of January.
deeply obliged.
Item 15. 15, my lord. This is a railway matter, my lord. I am filing the affidavit of service. Same thing, my lord.
So same order can be passed.
Same order as 13.
আচ্ছা ওই 13-এ যে অর্ডারটা হয়েছে ওইটাই।
Same. অর্ডারটা কবে থাকবে? Item 16.
16
16 and 17.
responded. Pre-application can hold.
Can 2, can 4.
Application for attainment of majority.
Okay.
আমাকে দিয়েছো কিছু কোথায় কি জানি আমরা
The claimant respondent number 2 and 3. There with a major.
It's just a minute. Can 2,
4, Lordship.
can 4, yes,
4, 5, 6, Lordship.
can 4. That is the respondent number 1 and 2,
No, 2 and 3, Lordship.
2 and 3. They have attained majority. Where is 3?
3 is a
Yes, 2, Rita Beshra and Lakshi Beshra. Okay, 4 has not yet attained majority. Yes, record an order. Learned advocates for the parties are present. The Can 4, application Can 4 of 2024 is taken up for consideration. Stop. In this application, the applicants being respondent number 2 and 3 have sought to record their majority. The applicants have, along with their application, filed their Aadhaar cards showing that they have attained majority. Thus, this application stands allowed. The respondent number 2 and 3 be shown as measured and necessary amendments be carried out by the department within 2 weeks.
Lordship, application can number 5, Lordship.
4, yes, can number 5.
5, Lordship, 2 and 3 after marriage, they are instead of surname,
2 and 3, that is
Rita Bachra instead of Rita Mahali. Lokhi
so. Is there any supporting documents with regard to that?
Aadhaar card and bank document, PAN card. Kindly see, Lordship, page number 7.
Rita Mahali. Page number 7. So far, Rita Beshra, that is Rita Mahali. And then
7.
Lokhi
Patar.
Lokhi Patar. And so far, the other
Other claimant respondent number Shantu Besera instead of Shantu Besera.
no, his majority is to be recorded probably. So how his surname will change.
Milord, respond. Milord,
So
respond.
this is a male person, is not a female.
Milord, may I indicate?
Shantu.
Milord, may,
Oh, Shantu is a female or a male?
Milord, may I indicate?
Male.
Milord, 2 and 3 were the minor daughters. Your Lordship, Milord, in Can 4 has just recorded that they have become majors. Milord, these 2 daughters, Milord, have subsequently been married. So, Milord, their surnames have changed. So, the surname of 2 and 3 is to be changed. And, Milord, as far as the 4 is concerned, 4 is the minor son of the deceased. Milord, his surname is recorded in the order sheet as BESRA. Milord, they say the Milord, one alphabet A is to be added into the surname of respondent number 4, minor son.
Okay, now this application. Okay. Applicant claimant number 1 and 2 means that is the
No, Milord, 2 and 3. 2 and 3 were the daughters.
Respondent number 2 and 3 means applicant number 1 and 2.
Applicant number.
Rita Beshra and Lakshi Beshra, they are married, and Rita Beshra is known as Rita Mahali and Lakshi Beshra is known as Lakshi Patar. So there should be a change in the cause title. So far, this minor daughter, Santu Besra is
minor son. He is the son.
His son.
Lordship.
He has attained majority.
No, Milord, his surname is Milord. The surname spelling, your Lordship will kindly see.
Oh, A has to be removed.
A has to be put in, Milord. That's what they say.
Oh, A has to be put in.
A has to be put in. Milord, the award of the tribunal said BESRA. That is how memorandum has been drafted. But they say, Milord, he is BESARA. One A is missing.
Is it there in the records, in the Aadhaar card?
Page number 6. Can 5, page number 6.
But in the claim petition, it was BESRA.
Even in the award passed by the tribunal also, it was
So far, with
BESRA.
regard to other applicants, it was same, BESRA.
Lordship.
Anyway, so far this 1 and 2 are concerned, their name will change.
Lordship, the surname would change.
Surname will change.
My lord.
But so far, here also some alteration is to be made.
Lordship, my lord, so that is can 5 in its entirety.
Yes, record an order. Learned advocates for the can 5. Learned advocates for the parties are present. This is an application filed by the respondent number 2, 3, and 4 stroke applicants. In the said application, the applicants have prayed that the name of respondent number 2, Rita Beshra, BESRA, be recorded as Rita Mahali by virtue of her marriage. Stop. It is further contended that the name of Lakshi, LAKSHI, be recorded as Lakshi Patar by virtue of her marriage. Stop. It is also contended that the name of Santu Besra should be recorded as Santu BESARA as shown in the Aadhaar card annexed to this petition. Upon perusing the petition and upon considering the documents filed in support of the surname of both respondent number 2, 3, and 4 applicants, this court is of the view that this application should be allowed. Thus, I allow this application. Let necessary rectification in the name of respondent number 2, 3, and 4 be made, and Rita Besra be amended as Rita Mahali, Lakshi Besra be amended as Lakshi Patar, and Shantu Beshra be amended as Shantu BESARA. Stop. The department to carry out the necessary amendments within 2 weeks. Liberty to mention.
There is one more can.
Six.
Can 6.
Can 6, yes.
For recording date of the respondent claimant number 1.
Okay, so the years are already on record. Yes, record can 6 of 2024 is taken up for consideration. This application is filed by the applicants respondent number 2, 3, and 4 for recording the death of respondent number 1, Sri
11 September 2022.
Sri Sundar Besra. The respondent number 1 died on 11/9/2022. Stop. As the years of the respondent number 1 are already on record, there is already on record being respondent number 2, 3, and 4. The abatement in such a case does not arise. Stop. Thus, the name of respondent number 1, Sri Sundar Besra, be deleted from the cause title being deceased. The department to carry out necessary amendments within 2 weeks. Liberty to mention.
Extremely great.
Yes, the paper books filed be kept with the record. Anyway, after it is carried out, we mention.
Eighteen.
18, not today. 18, yes.
I'm for the appellant. I'm for the appellant. Your Lord.
Yes, what is this appeal for? About?
Lordship, this is a small question, Lordship. The suit property is a Thika tenanted property, Lordship, and the respondent was.
See the order under appeal.
Yes, Lordship.
So is it ready for hearing? Paper books have been filed.
On 10/10/2023.
Lordship, paper book has not yet been filed, Lordship.
What is this applications for? This can?
Lordship, all the application has been disposed of.
Okay.
The can earlier can number 8464 of 17. 64.
Yes. So
It's
it's
for vacating of the estate.
okay. That is there. Now the question is, anyway, it is
Still, the appellants are enjoying stay.
anyway, it is pending for a long period. Let it be taken up in the month of January.
Lordship,
Paper books are ready.
Your Lordship,
Yes, Lordship.
Paper book would not be relevant required.
No, otherwise without paper books it will be difficult. So you are for the appellant.
I'm for the
So
appellant.
file the paper books.
Lordship,
Yes.
Only the question of law is
Yeah,
there.
trial court records have come.
Yes, Lordship.
Yes, Your Lordship. The trial court's records are come. Your Lordship, the order dated 10/10/2023. Kindly have a look.
Yes.
The order dated 10/10/2023, para 8.
So whether the trial court's record, the lower trial court records have come, that is the thing.
Your Lordship, as per my instructions,
A trial court record is check. Okay. So file the paper books. Yes.
Everything is ready.
Learned advocates for the parties are present. As the trial court records have come, let the paper books be filed on or before 9/1/2026. Let this matter appear on 12/1/2026 for hearing.
Item 20.
20. My lord, I beg to appear for the respondent. Respondent claimant. Whose application is this? Can one?
Milord, can one, Milord, was the stay application. Milord, pursuant to this court's earlier direction, Milord, I have secured the entire compensation amount before my lord's court. Milord, may I just show the original challan before your lordship? Your lordship will kindly dispose of the stay application. Huh? Huh? হ্যাঁ বলি stay absolute করে দিচ্ছি তুমি পেপার বুকটা রেডি করে নিও তাহলে সেটা তাড়াতাড়ি হয়ে যাবে ঠিক আছে
No, this is which case?
Milord, item 2020, Milord.
20. No, I find here some Union of India.
No, Milord.
National Insurance.
No, that is Union of India's item 19.
I don't know. এটা থাক এটা দিন ওই ফাইলটা দিন
সেটা নট দিস উইক হয়ে গেছে 19
Yes, record an order. Learned can also direct me for preparation of a paper. Learned advocate for the parties are present as the appellant insurance company has deposited the entire awarded sum. There shall be a stay of the judgment and award passed by the learned additional district judge, 4th Court, Paschim Mednipur, on 12/7/2018 in
record kori na.
MAC case number 126 of 2019 till disposal of this appeal. Yes, trial court's records have come. Yes, as the trial court's records have come, the respondents are granted liberty to file the paper books on or before 9/1/2026.
My lord, 2 weeks, at least 2 weeks after vacation.
9/1/2026. I'm granting them opportunity.
You applied for certified copy in the department.
On or before 16
ঠিক আছে
16/1/2026. Let this matter appear 15th. Okay, 15/1/2026. Let this matter appear on 19/1/2026. The records be sent to the department to enable application for certified copy for the purpose of paper books.
Grateful to your lordship.
And my lord, if I applied
Hey, well,
for a certified copy, department will give it
Yes, the certified copy be handed over expeditiously.
to the my lord respondent.
Yes, whoever is applied.
ওর মোবাইল নম্বরটা লিখে দাও না এখানে এখানে নিয়ে যাও ও আচ্ছা তোমার মোবাইল নম্বরটা দিয়ে দাও আমার অরিজিনাল রিসিপ্ট গ্রেটফুল টু ইওর লর্ডশিপ
আপনার নাম্বারটা আমি লিখে নেবো তাহলে পেপার বুকটা দিতে হবে স্যারের নাম্বারটা নিয়ে নেই My lord, 21, my lord, I beg to appear for the appellant, my lord. Pursuant to your lordship's direction, my lord, I served notices upon the respondent. My lord, it is my appeal. I am the claimant, my lord, appellant.
What is this? Can 1, your application?
Can 1 is for section 5. Can 2 is for passing, my lord, praying for necessary orders so that I can prepare the paper books.
No, but service has to, other side has to appear. Anyway, I'm considering your condonation application.
My lord, I have served upon the respondent as well. I have filed my affidavit of.
How long is the delay?
Delay is of, my lord, 155 days.
130 days.
130 days.
Yes, record and order. Learned advocates for the appellant is present. None appears for the respondents in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient cause is shown. Thus, the delay should be condoned. Thus, the delay in filing this application is condoned. Can 1 of 2025 stands allowed and disposed. Stop. The trial court's records be called for. The appellant shall take steps to prepare paper books. Upon arrival of the trial court records, let the paper books be filed on or before 16/1/2026. Let the paper books be filed on or before 16/1/2026. Let this matter appear for hearing on 19/1/2026. Yes, do you appear for United India Insurance Company?
Milord, I'll check up, Milord. I'll inform my learned friend who is appearing, Milord. I appear, but Milord, there are other educators.
It's first time appear.
So, Milord,
Otherwise he has to take steps to serve through the department.
Milord, Milord, your lordship will kindly not grant any further direction.
Anyway,
Milord, I'll inform him. He will within a day or two that who is appearing for company. Milord, I'll see to it that somebody appears.
Either you or somebody else, whatever it is.
One of the advocates would appear.
Anyway, I'm just keeping it for hearing on 19.
My lord can dispense with the LCR because I will prepare the paper book.
No, let it come. There's a procedural matter.
আসুক না আসুক 19 তারিখে মামলা আসবে যদি তুমি রেডি থাকো তাহলে মামলা করে থাকুক না
Grateful man.
স্যার এলেও ভালো না এলেও
না এটা তো আজকে ফার্স্ট টাইম না এটা স্যার ফার্স্ট টাইম
স্যার এলেও ভালো না এলেও তোমার মামলা 19 তারিখে থাকে Milord, 22 is insurer's appeal. Milord is appearing for the first time. Milord is praying for interim stay. I made Milord the statutory deposit of rupees 25,000 before your lordships.
Yes, record and order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 20th day of September 2025, passed by learned Additional District Judge, First Track, Third Court, Howrah, in MSC case number 175 of 2022 for a period of 5 weeks. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing of the claim petition till shall deposit the entire awarded sum as directed by the learned trial court within this period of 5 weeks.
My lord, less statutory deposit.
Less excluding the statutory.
Grateful to it.
In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall take steps to cause service of notice upon the respondents through the department. Stop. Let this
Lord, Registrar General be directed to deposit it in the Miller Renewable Fixed Deposit Scheme.
ওইখানে করে দেবেন। The Registrar General, High Court Calcutta, is requested to invest the sum deposited by the insurance company in a fixed deposit of a nationalized bank and renew the same from time to time.
Obliged to my lord.
Liberty to mention.
Extremely grateful, Your Lordship.
Item 25. For preparing an appeal.
Yes, these applications are to be taken up.
Yes, well, this application for condonation of delay for preferring a second appeal. My lord, this is a condonation of delay of 486 days. My lord, the ground for delay, my lord, kindly, my lord, paragraph 3.4 can one. Paragraph 3.
Did you file any opposition to this?
My instruction is let a formal objection be recorded. Lordship, I leave it to your lordship.
Yes, record an order.
Lordship, kindly send this matter to the honorable division bench so that this two bench the judgment has been affirmed in favor of the.
No, you see, after section 5, the matter has to be sent for admission to the division bench.
Yes, so kindly take steps because my clients also wants to disposal of this appeal.
Yes, learned advocates for the parties are present. This is an application for condonation of delay filed by the appellant in preferring this appeal. Stop. The delay in preferring this appeal is 486 89 days. Yes, which paragraph?
Or in 86 days.
Yes, 400 and
86
no,
days.
which paragraph you have stated that? Yes, 486 days. The learned, the appellant has contended that they have applied for all copies of the order in title appeal by mistake, and when consulted by the learned advocate, they obtain the said copies, and when instructed by the learned advocate to obtain certified copy of the judgment of trial court and appellate court, they obtain the same. Stop. Upon obtaining the certified copy of the trial court and the appellate court, it was handed over to the learned advocate on 1/8/2024. Stop. In November 2024, the learned advocate died by a train accident, and on December 2024, the appellants obtained the case file from the family members of the deceased advocate. Although learned advocate for the respondents objects to the grant of the prayer, but considering the grounds furnished by the appellant, this court is of the view that in the interest of justice, the delay should be condoned. Thus, I condone the delay in filing this appeal. The application IA1 of 2025 stands allowed and disposed. The matter be placed before the Honorable Division Bench, having determination for the purpose of admission of the appeal.
Yes.
Thank you.
Twenty-six. 27.
Not today.
28.
Not today.
29.
29, my lord, on 3rd November, your lordship, my lord, disposed of the stay application and directed me to take steps for service upon the respondent through my lord department. My lord, I have put in Taliban and notice of appeal on 11th November 2025, my lord. Since my lord, no one entered appearance on behalf of the claimants, my lord, kindly direct the department to cause service upon the and fix the returnable date.
Yes. Any report is submitted by the department?
I don't know.
কোনো department থেকে report এসছে regarding service? So 3/11. Anyway, 1 month have passed. Let it be in the month of January. Learned advocate for the you have deposited the Talabana.
Yes, on 11th November 2025, and notice of appeal.
Whether notice has been issued or not.
And direct the department to cause service.
Yes. Learned advocates for the appellant is present in terms of order dated 3/11/2025. The requisites have already filed by the appellant
on 11th November
on
2025.
11/11/2025. Stop. Let the department issue notice upon the respondents. Let this matter appear on 19/1/2026.
My lord, 30, I'm for the appellant, my lord. On 11th November 2025, Your Lordship, my lord, granted interim stay and directed my client to put entire audation together in case, my lord. Your Lordship, my lord, granted, my lord, limited period of stay, my lord. Kindly, my lord, make the stay absolute till the disposal of appeal.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the entire awarded sum in terms of order dated 14/11/2025, the
11/11.
terms of it is stated
In terms of 11/11.
in terms of order dated 11/11/2025, there shall be a stay of the judgment and award dated 28th August 2025, passed by learned additional district judge, special court, electricity Asansol, in MSC case number 182 of 2019 till disposal of this appeal. The appellant shall take steps to cause service of the notice upon the respondents through the department. Liberty to mention.
Get put, Your Lordship.
Yes.
Lordship, Mr. Shaunak Bhattacharya is appearing in this matter. He is on his legs before the Honorable Division Bench, Lordship. I am praying for an accommodation, Lordship.
Okay, not today.
Grateful, madam. Lordship, I am praying for not this week, Lordship.
Okay, not this week.
Grateful, madam.
Item 34.
Yes. Okay, not today.
Not this way.
Not this week.
35, 36, 37.
37, my lord. This matter, it's my appeal. I have given my written notes, but my lord will kindly grant me leave to take back that written notes because there are some errors.
Who is appealing? You are appealing for
He's
the.
on behalf of the respondents. I am on behalf of the
The
claimants.
matter was heard.
Yes, yes.
Your Lordship, yesterday I have given one sleep. Your Lordship, my court is lying in the court, but that has not been listed.
আমার written notes আছে।
Achha, let me do one thing. Let that application also appear along with this.
And I'll take back my written notes. I'll
Yes,
give him a
record
fresh
an order.
copy and I'll give my lord a fresh copy.
Yes, record an order.
Appear along with the court.
Learned advocates for the parties are present. Let the counter objection COT.
না না দেবেন আমি বলে দিচ্ছি ওটা তো ভুল আছে written notes
COT what?
COT 30 of 2021.
30 of 2021 appear along with this appeal
Lordship.
on 8/1/8/12/2000.
Next week, Your Lordship is not available.
No, next week I will be available.
The next week,
next week any
8/1/8/12/2025.
8/12 হ্যাঁ 8
Monday.
Next week, Your Lordship.
No, Monday. I have kept it on Monday. 8/12/2025. The learned advocate for the appellant is permitted to take back the written notes
I'm
of
grateful.
arguments and
I'm grateful.
submit a fresh one.
I'm grateful, my lord. 8th of January.
Yes. No.
Okay, I'm sorry.
Monday.
I'm sorry. Yes, December.
8/12.
Grateful, my lord. আমি ওটা নিয়ে নিই written notes আমি ফ্রেশ করে আপনাকে ফ্রেশ দিয়ে দেবো আপনার নামটা
দিন 38, 39.
It's in 39, same. Lordship, the cross appeal is lying here, but that has not been listed. Mr. Singh is appearing for the appellant.
So hearing is not concluded in this matter.
All this will be taken up in January.
Lordship, this is not very big matter, Your Lordship.
No, if I have not heard it, I'll keep it in the month of January. No, prior to that, you go to Lok Adalat. Thereafter, you come.
No, my learned friend challenged this materials on the ground that the vehicle was not involved.
Yes?
Vehicle is not involved.
Very well. Let him take instructions.
They will not take any steps also in the local law.
I'll take it up in the month of January.
If the vehicle is not involved, Your Lordship, local law will not hear this, Your Lordship.
No. In Lok Adalat, there will be no hearing on contest. If the client of Mr. Singh agrees to settle, then only there will be settlement.
No, my learned friend would not agree.
Will not fix it up in the month of January, my lord. Your lordship.
Yes, record an order. Learned advocates for the parties are present. Let this matter appear on 5/1/2026
Along with the cross appeal, Your Lordship.
along with COT.
ছাড়ো না তুমি তো এতক্ষণ গল্প করছিলে
I am giving the number, Your Lordship.
ওই সিওটিটা ব্ল্যাঙ্ক রেখে দিন, ওটা দিয়ে দেবে।
38. That COT is here, Your Lordship, that should be listed along with this.
Yes.
My lord, item 38, I was there. I am for the appellant, my lord. This, my lord, kindly make it, my lord, after vacation, my lord, it will take some time, my lord.
No, other side was here.
No,
I've just made it not this week.
not this, very well, not this week.
Forty-two, Your Lordship, Mr. Singh is appearing same matter, identical points, Your Lordship. As it
আচ্ছা,
is 39.
42টা সেম অর্ডার করে দিন, আইটেম নাম্বার
39
42।
39 and 42.
থাক, ছুটির পরে হোক, এই ছুটির আগে তো নেওয়া যাচ্ছে না, তাহলে এটা তো অর্ডটাকে না আনতে পারলে তো হবে না। হ্যাঁ, তাহলে জাস্ট একটা লাইন থাক এখানে, লেট দিস আইটেম 40
42, 39 and 42.
39 and 40।
এখন তো 42 কল হলো
42, you see identical point, Your
No,
Lordship.
court, what is the number of court?
I'm giving the number of 40. Your
Yes, learned advocates for the parties, let this matter appear with COT.
COT, I'm giving the number, Your Lordship. 3, it's COT 3.
আচ্ছা, ঠিক আছে, ওটা তাহলে বসিয়ে দেবেন। Yes, any matter where both parties are present?
On 5th January.
There is no matter, both parties are present.
42 on 5th January, Your Lordship.
It will remain in the list, okay?
Remaining.
Okay. 2 PM fixed matter আছে। আচ্ছা শুনুন, এই যে সিদ্ধার্থ, এই কালকে আর কোনো একমাত্র যদি একটা দুটো ফিক্সড হয়ে থাকে, একটা বোধহয় ফিক্সড হয়েছে সম্ভবত, হ্যাঁ একটা দুটো বোধহয় ফিক্সড হয়েছে, সেটা ছাড়া আর কোনো হিয়ারিং ম্যাটার কালকে দেবেন না। ওই শুধু অ্যাপ্লিকেশন আফটার 12, না ওই অ্যাপ্লিকেশন যেগুলো আছে সেগুলো থাকবে, টু বি মেনশন আর অ্যাপ্লিকেশন, টু বি মেনশন অ্যাপ্লিকেশন। আর যদি কোনো স্পেশালি ফিক্স করে থাকি, আজকে যেরকম একটা জাজমেন্টে ছিল, জাজমেন্ট আজকে দেখি নেই, না 4 তারিখ বলে আমার অর্ডার শিটে করা আছে, ওটা কালকে টু বি মেনশনটা দিয়ে দিন, না তো সোমবারে থাকতে হবে। হ্যাঁ, আমি দিয়ে দিচ্ছি।
Next matter. Number 32.
I appear on behalf of the appellant, my lord.
Yes. Yes, on the last occasion, you referred to the affidavits filed by the respondents before the appellate court with regard to your section 5. Yes, whether there was sufficient cause or not.
Yes, that
in,
was the issue.
in your appeal.
I further urged before your lordship, whether the point of the substantial question of law was framed by the division bench while admitting the appeal, whether further substantial point can be raised since it was a dismissal of the.
No, another question at best point of law you can argue is this, whether the appeal, whether while considering section 5 application, merits of the case can be gone into.
Yes, yes.
That is at best.
Yes.
Nothing more than that.
Yes. My lord was kind enough to direct me whether there are any judgments on such issue or not.
That is one thing. Regarding sufficient grounds, whatever is there in the record is there.
Yes.
You cannot improve that. Whether while considering the appeal, the appellate court, or while considering application under section 5, whether courts can consider the merits of the case or not. That is the thing. That is another point of law.
Yes.
What my learned friend was praying leave for is to agitate on the point of jurisdiction.
No question. That cannot be. The division bench has considered that. I don't think it necessary. No. You see,
No,
that point, you see, will cover that section in section 5, whether merits of the case can be considered. If it can be considered, then the appellate court ought to have considered that.
The appellate court has not considered.
No, whether he can do or not while considering section 5. If you succeed in doing that.
The difficulty was that whether the learned court below, trial court below, had jurisdiction since to try the.
No. That you see, all these points are left before the appeal court. Okay. If the appeal is heard. Now the question is, while considering your section 5 application, did you plead in your section 5 that regarding that?
The section
5, or the question is,
so section when the section 5 was moved, the only point was taken before the court below was what was the reason for the delay for preferring the appeal.
Now there is only one question, you see, whether the court, while considering section 5 application, can suo motu consider the merits. That is the thing. And entertain a section 5 application to prevent a meritorious case being thrown out. That is the power while considering. Whether at the time of considering section 5 application, the court can condone the delay to prevent a meritorious case being thrown out. That is the point at best you can urge. And the others are already on the record.
Since my lord was on that issue, my lord, I was referring a judgment
Yes. Any section 5 judgments you refer that also?
Section 5, obviously I will show
Yes,
the
yes,
section
yes.
5 judgments. But before that, my lord, just give me 1 second, my lord.
Verma. 2005. Yeah, 2000.
2005 1 SCC 436. SCC.
Okay.
1 SCC 436.
2005.
Anyway, give a Xerox copy.
Yes, yes, I shall. I shall.
Verma versus Honorable Judge.
The state judgment, I'm just relying one paragraph. 19.1 in Siudan Singh versus Darwa Kumar rendered by 4 learned judges of this court. One of the question that arose whether the dismissal of appeal from a decree on the ground that appeal was barred by limitation was decision in the appeal. This court held, we are therefore of opinion that whether a decision is given on the merits by the trial court and the matter is taken in appeal and appeal is dismissed on some preliminary ground like limitation or default in printing, it must be held that such decision then it confirms the decision of the trial court on merit itself amounts to appeal being heard and finally decided on the merits, whatever may be the grounds for dismissal of the appeal.
Okay, what is the citation?
It is, my lord, AIR 1966 SC 1332.
It was relied upon.
It was relied. But 2005 1 SCC
2005
1 SCC 436.
1 SCC page
436.
436. The other is AIR 1966 SC 1332.
My lord.
Okay. So what is the relevant law laid down? Ratio decidendi?
Well, the ratio is, my lord, it is decided it must be held that such dismissal, when it confirms the decision of the trial court on merit, itself amounts to an appeal being heard and finally decided on merit, whatever may be the grounds for dismissal of the appeal. So we have filed the suit. They have filed a suit decreed, challenging we preferred an appeal dismissed on default or limitation, whatever may be. Challenging we have preferred a second appeal. Now the appeal has to be considered on its merit. This was the head, my lord. So I was urging that another substantial question to be framed with regard to the jurisdiction, inherent jurisdiction, whether trial court had inherent jurisdiction to try the suit or not.
So on the other way, while considering the Section 5 application, the appeal court ought to have considered
if my lord kindly considers on the view that the Section 5 has been taken up for hearing, Section 5 was dismissed on its merit. While dismissing the merit, the judgment came into finality. So in the second appeal, the Honorable Supreme Court says, continued, that the appeal should be had on its merit, not only on the point of the Section 5.
But the grounds framed is
that if my lord so desires, there are judgments of our High Court also, as well as the Honorable Apex Court.
Anyway, let us read.
At the time of hearing of the appeal also, if the court deems fit, additional substantial questions.
Anyway, today you conclude. Let me hear your learned friend. Thereafter, you file your written notes giving those citations and these judgments.
I don't want to disturb my learned friend. What?
Anyway, anything else to submit?
Yes, I have.
Yes. So please conclude your submissions.
I was urging that another substantial point should be, it can be framed on the, since the entire issue I have placed on the earlier occasion, the Section 102 of the West Bengal Cooperative Societies Act, which bars the trial, the issues of the cooperative in a civil suit. It was done there.
Okay, let me see what are the contents of the judgment, that relevant portion. What are the facts there? The book, yes. Give the book.
May I make a photocopy and thereafter give?
Yes. Yes, the next.
I was relying on the judgment of trial passed by the trial court. Page 88, my lord.
No, that is there. Okay. Let us confine ourselves first within the judgment of the appeal court. Your ground.
Yes, page 88.
Page 88 is the appeal court.
Yes, page 88.
Yes, page 88. 88.
May I place the judgment is entirety or the
No, relevant portions, please place. You are placed on the last occasion anyway. What is the age of these two appellants?
original appellant died? His legal heirs came into picture.
No, died prior to the appeal.
Pendency of this appeal.
During pendency
So
of
this
this
second appeal.
Oh, pendency of the second appeal. So what is the age of this person? No, actually, the original appellant, what was his age?
He was senior citizen at the time of preferring the appeals, my lord. If my lord, when the appeal was preferred, my lord.
Yes, it is these are the grounds shown by the original appellant.
Yes.
Original appellant who died when? During the pendency.
Of the second appeal.
No, yes. Now the question is.
That can be ascertained from the LCR, my lord, what was his age at that point of time.
No,
Because
question is.
he preferred application.
You see, whether regarding his elements that he died within a short period, this ground can be taken into consideration. So, question is what that means. You see, he died when the appeal was disposed in
2015.
2015.
15.
Appeal.
Yes.
Yes. First appeal.
Okay.
First appeal was dismissed in 2015.
That is Manoj Kumar Chakraborty.
And
this person pendency of the second appeal.
When did the second appeal preferred?
Thereafter. Second appeal was preferred within time.
Okay. Now the question is when and in what age this person passed away. So we can consider what was the age during the time of the first appeal.
Application was preferred for substitution of the parties. Yes, right now I don't have that.
Or in the original application for
substitution application. From the substitution application.
Or stay application.
Yes, from the substitution application. From the substitution application, it can be ascertained when he died.
2017, 10th October. 2017, 10th October, at the age of 72 years age, he died.
72 years age is died. That means okay. And during the dismissal, we can presume that 70 years of age.
No,
so this
65.
Huh?
7 years. 2015.
So in the age of 67.
70.
At the age of 70, he passed away. In 2007. That means at the time of appeal. 15 is this appeal.
Yes.
Within 2 years. And the ground of illness is during. That is the.
Because if my lord considers my earlier days hearing, my lord, that when the suit was filed, he initially took steps and appeared before the suit. During the time of cross-examination, he initially appeared. He also adduced evidence. Subsequently, due to illness, he could not come. And the entire responsibility he given his to lawyer to approach the learned trial court to ascertain the situation. In that phase, my lord, his evidence was closed. Suit was decreed in the favor of the cooperative society. Thereafter, after recovery, my lord, he approached his lawyer, wherein he came to know that the suit was decreed in the favor of the society. He immediately preferred an appeal.
So that means knowledge and illness. These are the two grounds.
Yes. Now, during the pendency of the appeal, at the time of the appeal, he stated that the reason of his absence and why he could not prefer the appeal within time. That was not considered by the court below, and the section 5 was dismissed. Challenging which we have preferred the appeal before this honorable court in 15.
On 17th, the original defendant, Manoj Chakraborty, expired, leaving his
Death is due to old age ailments.
old ailments because he was suffering from some cardiac issues. He was regularly under treatment in Ruby General Hospital as well as PLS Hospital. Those documents were placed before the trial court, first appellate court, considering his in the section 5, which was not considered at that time.
So his age ailments and subsequent event
Yes.
is his death.
Yes.
Yes.
Now, Mother, in this appeal also, we have filed an application under Order 41, Rule 27.
Yes, it is be heard along with this.
Yes. Which is Can 252 of 2019. The application also came up for hearing earlier occasion. There was a direction for affidavits.
Before the division bench?
No, single bench.
Okay.
Earlier coordinate bench. Now the appeal in that application also, if my lord kindly sees that I have on the record itself, we have further annexed the medical documents. My lord kindly sees the application once.
Anyway, no medical documents which were not.
This is the trial court. Obviously, that's the reason.
That is appeal court.
Appeal court. And
anyway, that will be taken into consideration.
From annexure P2 at page 41, we have details that during the phase when he was in hospitalization, when the decree was passed in favor of the society, we have given the details from the hospital. Now the court was of view that
yes, doctor should be summoned.
Doctor should be summoned.
That is the reasons given. Okay.
Only that was the reason for which these medical documents were not taken into consideration. Although, my lord, we have referred judgments of these various courts as well as the High Court also, saying that liberal consideration to be taken while dealing the Section 5 application.
Anyway, you conclude, you give those citations, and if you want your written notes, you can give your written notes also on the next day. So let me hear your learned friend.
May I recite the judgments, my lord?
Yes.
2002 ACC 195. Paragraph 12. Page 201, my lord, paragraph 12.
Yes.
May I place? May I place? Thus, it becomes plain that the expression sufficient cause within the meaning of Section 5 of the Act or Order 22 Rule 9 of the Code or any other similar provision should receive a liberal construction so as to advance substantial justice when so negligence or inaction or want of bona fide is imputable to a party. In a particular case where expression furnished would constitute sufficient cause or not will depend upon the facts of each case. There cannot be a straitjacket formula for accepting or rejecting the explanation furnished for the delay caused in taking steps. But one thing is clear, that the court should not proceed with a tendency of finding fault with the cause shown and reject the petition in a slipshod over jubilation to disposal drive. Acceptance of explanation furnished should be rule and refusal and exception. More so when no negligence or inaction or want of bona fide can be imputed to the defaulting party. On the other hand, while considering the matter, the court should not lose sight of the fact that by not taking steps within the time prescribed, valuable right has accrued to the other party, which should not be rightly defeated by condoning delay in routine manner. Whatever, however, by taking a pedantic and hyper-technical view to the matter, the explanation should not be rejected when stakes are high and arguable point of fact and law involved in the case, causing enormous loss and irreparable injury to the party against whom the causing enormous loss of whom the lease terminates, either by default
Yes,
or
so there is
remand.
an observation that if the case involves merits.
Yes. If my lord kindly see, last occasion I also placed my lord the 102 of the Cooperative Societies Act with the jurisdiction, the trial court proceeded.
The merits was there in your grounds of appeal.
Yes.
Regarding jurisdiction
Yes.
and maintainability.
But that cannot be entered into since the section 5 was dismissed.
And that was a matter of record.
Yes. The explanation should be the rule. My lord, the acceptance of explanation should be rule. We have.
Any other?
Yes, I have. The 2018 5 SCC 127.
Yes.
Paragraph 11 onwards. We have perused the contents of the applications and the affidavit filed by the appellant before the High Court seeking condonation of delay in filing the appeal. The cause impleaded by the appellant herein was relating to his prolonged illness during the period in question. The appellant also filed medical documents to support the factum of his illness during the relevant time. It is not in dispute the appellant is an old man and is late 60s. It is also not in dispute that he did suffer heart disease during the relevant period, and later he was down with a dengue fever. It is also not in dispute that he was hospitalized to get medical treatment for these two ailments for a long time during that period. It is also not in dispute that he was mentally disturbed due to his disputes going with his family and not able to attend his day-to-day duties due to his old age and prolonged admit. It is an admitted fact the High Court did not dispute the genuineness of these documents and not dispute the genuineness of the documents filed by the appellant in support of the cause pleaded. On the other, High Court found the fact the appellant did suffer the ailments. In the light of the above mentioned undisputed fact, in our opinion, the High Court should have taken a liberal view in the matter and held the cause shown by the appellant as sufficient within the meaning of Section 5 of the Limitation Act, and accordingly should have condoned the delay in filing the appeal. One cannot now dispute the legal proposition that the earlier view of this court that the appellant is required to explain the delay of each day till filing of the appeal, since being diluted by later decision of this court and is therefore held no longer a good law. In our considered opinion, having regard to the totality of the facts and circumstances of the case, the cause shown by the appellant, which is duly proved by the documents, we are inclined to hold the cause shown by the appellant for condoning the delay in filing the appeal before the High Court was this sufficient cause within the meaning of Section 5 of the Limitation Act, and therefore the application filed by the appellant for condonation of delay of 554 days in filing the appeal deserves to be condoned. It is accordingly condoned, but it is subject to condition that appellant pay cost of 10,000 to the respondent number 1.
Yes.
Mm-hmm. 1998 7 SCC 123. from paragraph 9 onwards.
Yes.
Paragraph 9 onwards. It is axiomatic that the condonation of delay is a matter of discretion of the court. Section 5 of the Limitation Act does not say that such discretion can be exercised only if delay is within a certain limit. The length of delay is no matter. Acceptability of the explanation is the only criteria. Sometimes delay of shorter range may be uncondonable due to the want of acceptable explanation, whereas in certain cases delay of very long range can be condoned as explanation thereof is satisfactory. Once court accepts the explanation is sufficient, it is a result of positive exercise of discretion, and normally superior court should not disturb such findings, much less in revisional jurisdiction, unless the exercise of discretion was on wholly untenable ground or arbitrary or perverse. But it is a different matter when the first court refuses to condone delay. In such cases, superior court would be free to consider the cause shown for delay afresh. It is open to such court to come to its own finding, even unterminated by the conclusion of the lower court. Reasons for such distance is thus: primary function of the court is to adjudicate the dispute between the parties and advance substantial justice. The time limit fixed for approaching the court in different situation is not because of expiry of such time a bad cause would transform a good cause. The rules of limitation are not meant to destroy the rights of the parties. They are meant to see the parties do not resort to dilatory tactics but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by reason of legal injury. The laws of limitation fixes a lifespan for such remedy for the redness of the legal injury so suffered. Time is precious. Wasted time would never be revisited. During the efflux of the time, newer causes would spout up, necessitating newer persons to seek legal remedy by approaching the court. So lifespan must be fixed for each remedy. Unending period of launching remedy may lead to unending uncertainty and consequential anarchy. The law of limitation is thus founded on public policy. It enshrines the maxim so and so. It is for general welfare, and the period of limitation to put litigation. Rules of limitation is not meant to destroy the rights of the parties. They are meant to seek parties to do not resort to dilatory tactics but seek their remedy promptly. The idea that every legal remedy must be kept alive for a legislative fixed period of time. The court knows that refusal to condone delay would result in foreclosing the suitor from putting forth his cause. There is no presumption that delay in approaching the court is always deliberate. Court has heard that the word sufficient cause under Section 5 of limitation would receive a liberal construction so as to advance substantial justice with a so and so. Even these two judgments were also referred in the trial court. Now, my lord, before that, my lord, if my lord kindly considers just portion is page 1, the plain starts. Just one thing I want to place before your lordship. Yes, my kindly comes to page 5, D. Page 5D.
Yes.
I should be candid before my lord. The plaintiff purchased 1.22 acres of land equivalent to 3 bighas, 13 kotas, 14 chitas, recorded in 4 RS lag number so and so, Khotiar number so and so, from Srimati Shishir Kona Guho on the basis of the deed of conveyance dated so and so. If my lord kindly sees, this was a similar issue.
Yes.
This was a similar issue wherein a dispute arose between Srimati Shishir Kona Guho and the society.
Yes.
My learned friend was aware because he appeared. This matter also came up before this Honorable High Court. In the division bench of this court, my lord, between the same society. If my lord kindly sees, ultimately suit, thereafter from suit, culminated to first appeal, wherein the Honorable Division Bench of our High Court, that the suit was instant not made. Page 10, paragraph 10, paragraph 10.
No, was this an appeal against refusal of section 5?
No, not so.
Merit.
Merit, on the merit.
Yeah, whatever it
suit
is. This.
Came, I want
Point of jurisdiction.
Yes.
This matter was decided on the point of jurisdiction.
Jurisdiction. That's
inherent lack of jurisdiction.
No, that is there. But you see, jurisdiction point is also a point of with regard to merit.
My lord.
Point of law. But it whether it was while considering any application for section 5.
No, but what
Simplicity.
happened? What happened this case? In this case, my lord, the suit was filed in the civil court in the year 1995 by one Sisir Kona Go, since deceased, for specific performance of a contract. So that suit was on the peremptory board. Then the society filed an application under Order 7 Rule 11 for rejection of the plaint on the ground that the civil court has no jurisdiction to entertain this kind of dispute because this arises out of the business and affairs of a registered cooperative society. And the suit was dismissed. Order 7 Rule 11 application was allowed. Thereafter, an appeal was preferred before the Honorable High Court. The Honorable High Court says, while deciding, as your Lordship is very well aware, there are catena of judgments that while deciding an application under Order 7 Rule 11, the court cannot travel beyond the plaint.
Yes.
So on that occasion, it was found that the court has traveled beyond the plaint and decided the matter that the civil court has no jurisdiction. So it was remanded back with a direction that a first maintainability point will be decided by the learned court trial court, and if it is found that the suit is maintainable, only then they will proceed, the court will proceed to dispose of the matter on merit. So accordingly, both sides contested, and once more, on the point of maintainability, the suit was dismissed on the ground that civil court has no jurisdiction to try this kind of dispute.
That is from the plaint itself.
From the plaintiff. Thereafter, an appeal was preferred before the Honorable High Court. Which my learned friend is this appeared before the division bench, and division bench decided on the affirmative, and they are relying on a special bench judgment that because of the business and affairs of the cooperative society is squarely and exclusively covered under the Cooperative Societies Act, which is a special statute, so the civil court has no jurisdiction. So that was the background of that case, and I will be submitting. Let my learned friend finish. Our case will be different. The point is this, then why Sisipana case is to be decided.
Since there was a dispute between the society, it should be. I have read the judgment of the Honorable Apex Court also, which says that while dealing it, since it is a hearing of a second appeal, this point has to be considered. And the society, and if the court had not had inherent jurisdiction, considered that the point can be taken at any point of time and should be adjudicated. If my so desires, I can reside judgment on the point of the inherent jurisdiction can be taken. I can reside your judgment on the issue also.
Now you see, you are relying upon a inherent lack of jurisdiction decision. But suppose you move a section 5 application before me. Now I am considering section 5. You may have a very good case. So the question is, whilst considering section 5, can I go into that?
I'm not saying.
So that similar same thing applies.
Since my lord is
So while
hearing,
suppose I would have had section 5 application and you have come at a belated stage, whatever it is. Now, while dealing with your section 5 in second appeal, can I go into those questions?
since my lord is hearing a second appeal itself, kindly consider on that point, because that cannot.
That is means, you see, if I can hear a question on the points of merits in second appeal in section 5 application.
If my lord kindly sees the
Of
judgment.
course, you see, that means I'll be traversing beyond my jurisdiction. A division bench has jurisdiction to entertain an appeal on the merits. Okay, but the moment I sitting in the single bench and considering section 5 application is going to decide this case on merits, see the merits, it will be beyond my jurisdiction.
I do not consider in that manner, my lord. The division bench at the time of admission has framed two substantial question of law. Had framed two substantial. My lord has a power under the.
Had the division bench considered that issue, that yes, that maintainability.
But that can be considered by your lordship at the time of hearing. The
prima
CPC provides so.
Prima facie, the division bench did not think fit. The appellate court also did not think fit.
The appellate court has considered only on the issue of substantial question of law. The appellate court has only considered on the point of section 5, did not consider. The appellate court did not give a liberal construction to the cause shown.
Anyway,
so that cause was never agitated. If my lord kindly sees 2013 10 SCC 136, this judgment. Paragraph 9 to 11.
No, you see, this is with regard to the jurisdiction of this cooperative society in consumer matters.
Yes.
So this does not deal with section 5. I think a similar judgment I also delivered in 227 jurisdiction regarding jurisdiction of the court.
My lord, I am only trying to point that the object of jurisdiction can be taken at any phase of time. So kindly seize paragraph 11, my lord. Kindly seize once. Paragraph 11.
Yes, so let me see that decision over the point of jurisdiction can be taken while considering section 5 application also. If you can show, very well. Your case will succeed, definitely.
Section 5, I am giving.
Whatever you see, if I find any decision that yes, in section 5, court can go into the maintainability and the merits also, and should not throw it out at the threshold. A good meritorious case, then your case is sure to succeed.
I have relied that the judgment where the meritorious case should not be decided in that manner. Only liberal views should be taken while dealing.
Yes, paragraph 11 this is with regard to the jurisdiction, with regard to cooperative societies, probably. Yes, jurisdiction.
Thus, assuming for assumption of jurisdiction by court, tribunal, existence even when the law does not permit any court, tribunal, authority, forum to usurp jurisdiction on any ground whatsoever, in case such authority does not have jurisdiction of the subject matter. For such a reason that it is not objection as to the point of suing, place of suing. It is an objection going to the nullity of the order on the ground of want of jurisdiction. Thus, for assumption of the jurisdiction by a court or a tribunal, existence of jurisdiction as factor is a condition precedent. But once such jurisdiction fact is found to exist, the court tribunal has power to decide such adjudicatory fact or facts in issue. The act as enacted is provided for better protection of the interest of the so and so. Such rights of the protected. Even it's quite clear that these point of jurisdiction, if a forum do not have jurisdiction to consider, that cannot be agitated due to the dismissal of the section 5 application. Now here is the second appeal. The jurisdiction point can be as per either section, paragraph 11, the jurisdiction point can be taken at any stage, even second appeal court also.
Very well. Now appeal, the scope of this appeal is limited.
It goes to the root of the matter.
Scope of the appeal is limited. Okay. So that's all with regard to.
If my lord kindly sees the, if my lord kindly sees that application once, that can application on, I have, that is in the record also, if my lord sees.
Yes, order 41, rule 27. Very well. Let it be there. Let you. I heard you on the points of law, on the facts. Now, if anything else you want to add, you give it in your reply. Let your learned friend submit. Yes. So these are the three decisions you have cited.
The three decisions, kindly also consider the judgment of this court also, my lord, the division bench judgment.
Whatever
which
it is,
Sri Konagu, I have handed a copy also.
Total. Okay.
And also the issue of that is 2013-10 SCC, that is on
Yes,
the,
yes, yes. This is there.
page paragraph 11.
Okay.
The jurisdiction point can be raised, my lord.
Okay.
I have also relied last occasion 102 of the Cooperative Societies Act, where the civil court is barred.
Yes. Yes. What do you say?
My lord, the conduct of the parties is to be taken into consideration. Why? Suit was filed in the year 2000, in 1993.
Yes.
Kindly come to page 18 of the paper book, my lord. This is the prayers made by the plaintiffs. Page 18, my lord.
Page 18
of the paper book. The prayer portion of the plaint.
Yes.
Lordship got it?
Yes.
The plaintiff therefore pray for declaration that the plaintiff's Ponchoshire township covering the land described in the Schedule C below includes also the A schedule land of which the plaintiffs are the owners and the defendants have no right to use and occupy any part of A schedule property or occupy the house in B schedule property wrongly constructed by them. Recovery, and B, recovery of car's possession of a scheduled property by demolishing and removing the house and structure and B schedule thereof and evicting the defendants thereof. A decree for main profits, etc., etc. So, my lord, it was a title suit, and the title suit for declaration of ownership.
Yes.
Because the defendants also claimed ownership over the same plot of land. So the title was in dispute. But it so happened, I must admit, that it's a cooperative housing society. Undeniable fact.
No, is it a dispute between the society and one of its members?
No.
Society and a third party?
Yes, third party. But my lord, I cannot be, I must be fair. The judgment of this honorable court, a special bench judgment, and the judgment delivered by the bench of Justice Bhattacharya and Banerjee dealt with this point and says under section, at that time it was section 95. Now it is 102. It was under the previous act of 1983. That any affairs, business and affairs relating to the cooperative society is to be referred to the registrar.
Anyway, that you have to see whether the facts of this case applies to the.
I'm coming to that.
If it applies, then you have to accept that.
Yes, yes, yes.
Either here or there, whatever it is.
Yes, that's true. That is one of the point. One of the point which my learned friend has raised. Now, it is not a question of third party, because in the special bench judgment, it was decided by the High Court that because there was a conflicting judgment, the High Court says no, since it is business and affairs of the cooperative society, even a contractor claiming payment is also business and affairs of the cooperative society, so it has to refer to the registrar. The judgment which has been relied upon by my learned friend between Sisir Kona Guho and this society, reported in 2008 SCC online, there also the question is that there was a registered agreement for sale by the cooperative society to the agreement holder, and it was decided by this honorable division bench. No, that also relates to the business and affairs of the cooperative society. Even a suit for specific performance of a contract, that should also be referred to the Registrar of Cooperative Society, in order to adjudicate the dispute. The only point then remains whether it is a business and affairs of the cooperative society or not. Here, the prayer is for declaration of title, ownership. When somebody prays for a declaration that whether I am an owner of a property or not, that includes title. Then comes the question, what is title? Your Lordship has dealt with many suits earlier, and your Lordship knows better than me, better than any of us, that title means that not only the ownership and instrument of registered instrument, but also entitlement or right accrued on a particular immovable or movable property, right accrued. So that is why it becomes a title. Now, whether a title aspect can be decided by a civil court or not, that has been agitated by my
Whether the title aspect can be decided by the registrar or not.
Yes, my point is that whether it can be
Title to immovable property.
movable or immovable both, because movable properties title is something else, and
so immovable properties title can be decided by any
that
other
is to be
forum,
decided by
save and except the civil court. Whether
that is to be decided in light of the,
because you see under section 9 courts are barred. There is a bar in deciding suit
yes,
if prohibited under the law.
That was the application we preferred. Anyway, the society made such application. The question is that section 9 says the civil court will have jurisdiction unless it is specifically barred or expressly barred. Now, whether in this matter the court's jurisdiction, civil court jurisdiction is barred or not, that is one of the issue which was before the trial court. Now, trial court decreed the suit in the year 2008. Now, the dates are very important because your Lordship has rightly pointed out that there is a matter arising out of dismissal of an application under section 5 limitation. Now, the suit was filed in the year 1993. In the year 1993. And it was decreed on 20th February 2008.
Yes.
And the appeal was filed sometime in 27th of July 2009. According to the appellant, the delay was about 439 days. Now, an application for an appeal was filed. An appeal was filed, my lord, on 27/7/2009. But the point is, when the application for condonation of
delay is 489 days.
Oh, 39 days.
39 days.
That is the case made out by the plaintiff. Appellant, sorry, appellant. Now the point is, when the application for condonation of delay was filed, kindly come to page 93 of the judgment of the first appellate court.
Yes.
Learned advocate of the respondents argued that the judgment was passed in the lower court on 19/3/2008.
Yes.
এখানটা ভুল হবে, এটা মনে হয় ভুল, because it was filed in 20 decreed on 20th February 2008. One of it must be mistaken. Certified copy of the judgment and decree was applied for by the appellant on 26th of November 2008. This date can be ascertained from the trial court's record or the LCR.
So
court fees were notified on 10/12/2008. Folios and court fees were deposited on the same date. Certified copy was ready for delivery on 20th December 2008. Certified copy was taken on deliver on 2/4/2009. from the copying department. Appeal was filed on 27/7/2009 and application for limitation was filed on 28/8/2009. That means a month thereafter.
Appeal was filed 27/7/2009.
And the application for condonation of delay was filed on 28th August 2009.
So 19/3, that is a certified copy 26/11, and 2012 it was made ready.
Yes. So limitation has
from
to be counted from
2012,
that day.
from 2012, so it is
More than
27/7.
Yes. Learned advocate of the respondent father argued that the appellants had engaged three renowned lawyers of the bar, namely Sri Otindra Mohan Mukherjee, Sri Meet Doctor, and Susanto Chel in the lower court, but unfortunately, Advocate Susanto Chel died on 23rd of October 2010. Learned advocate of the respondent further argued that it is settled position of law that memo of time barred appeal has to be filed accompanied by an application under Section 5 of the Limitation Act. Otherwise, the appeal is not maintenance. To strengthen his argument, learned advocate of the respondent cited a judgment published in year 2001, NOC 300 Gujarat, Paschim Gujarat વીજ Company Limited versus Kemchaj Nathabai Gahavi 2007. AIA Bombay R7 says this was the judgment. This is there on the LCR. I will also place this judgment. Learned advocate of the respondents further argued that the appeal is barred by limitation for 464 days.
See, it is more than 1.5 years. This is admitted position.
464 days from the date of passing of the order if the appeal is assumed to be filed on 27/7/2009. But according to the provision of Order 41 Rule 3 of the Code of Civil Procedure, it will be deemed to have been filed on 28/8/2009. In that case, the appeal is barred by limitation of 496 days and not 439 days as alleged by the appellants. Learned advocate of the respondent's father argued that it has been alleged that the appellant number 1 was suffering from illness till 24/7/2009. But Exhibit 1 reveals the appellant number 1 was discharged from the hospital on 14th of February 2009. And at the time of filing application under Section 5 of the Limitation Act, a same medical certificate was filed with the same verbatim language by the same doctor but on different date.
Page 95. Fourteen to 2009.
Yes. Learned advocate of the respondent's father argued that the appellant number 1 in his evidence admitted that he instructed his learned advocate over telephone for procuring the certified copy of the judgment, and thereafter he met with his learned advocate for preferring appeal. So from the evidence of the appellant number 1, it has not been proved that he has no bona fide and diligence in filing the appeal, and hence the laches are intentional and there is no sufficient cause for condonation of delay. Learned advocate of the respondents further argued that the medical paper, that is Exhibit 1 to Exhibit 14.
Yes, I have a fixed matter at 3 p.m.
My lord.
So you complete on the next day?
I will complete, my lord.
My lord, I was in that event, my lord, I was resigning the judgment AIR 1966 SC 1132 paragraph 14 last portion. The last portion, we are therefore.
Okay, I shall consider that also. Give your learned friend.
In the meantime, if my lord grants me an opportunity to file an application for.
No, I'm hearing in the midst of this hearing, no question of any filing application. Let me hear the matter. You have already filed one application.
Under Order 41, Rule 27.
Okay, that is there. Yes, record an order. Learned advocates for the parties are present. Learned advocate for the appellant has completed his submissions. However, learned advocate for the respondent submits but could not conclude his submissions. Let this matter appear for further hearing. আচ্ছা, কালকে কি ইয়ে আছে? দেখুন তো কালকে হ্যাঁ 10:30 আচ্ছা 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 ঠিক আছে কালকে ইয়ে জাজমেন্ট তো না টু বি মেনশনড থাকছে কালকে মানে সামনের সপ্তাহের মধ্যে একটা ফিক্সড ডেট দিয়ে দিন আর কি
Whether it is the why the bank was not due.
Industrial time, 11 তারিখ বুধবার না বৃহস্পতিবার হুম ফার্স্ট হাফই হ্যাঁ 12টার সময় ম্যাটার ফিক্স আছে হ্যাঁ নাকি তাহলে 11 তারিখে 2টোর সময় রেখে দিই 2টোর সময় তো নেই হ্যাঁ ইয়েস আই এম কিপিং ইট অন 11th at 2 p.m. Let this matter appear on 11.
For a longer duration also, so that we can
Yes, I am keeping it at 2 p.m. At best, it will take 1 hour. 11/12, 2025 at 2 p.m. So whatever time you get, you reply. ঠিক করে থাকে এটা এর মধ্যে যেন পেপার হয়ে
Next matter, next week matter, item number 33.
For the applicant, my lord, I have read by Mr. Chari, my lord, he will be on virtual mode, my lord.
Lord, your lordship can hear me, Lord?
Yes.
Now, on the last occasion, I'm sorry I'm on virtual mode today, Lord, for a personal difficulty.
Anyway, you submit.
Yes, Lord. Now, on the last occasion, Lord, I had placed before your lordship till below the plaint. Lord, if your lordship, just to give your lordship a broader aspect, Lord, we had given to your lordship, Lord, a list of dates.
Yes.
Now, my lord, if your lordship looks into the list of dates once, before I take your lordship, Lord, back to the written statement, which I would request Mr. Arifin to place it for your lordship's kind consideration, Lord, after I show this to your lordship.
Yeah.
Now, my lord, your lordship will find in the list of dates in 1962, my lord, the money suit was decreed on compromise.
Yes.
My lord has the list of dates, my lord?
Yes.
Yes. My lord, your lordship will find on 28th of November 1962,
Yes.
The degree was on compromise where, my lord, the Dhirendranath Boiddo, that's my predecessor, agreed to pay rupees 750 in, my lord, 4 yearly installments.
Yes.
My lord, these are exhibits. Yes, exhibits 8. Your lordship will find that at exhibit 8. I'll take your lordship to that later. Then kindly marks the date, that is important.
Yes.
Then, my lord, on 28th of November 1962 itself, my lord, it was again, there was, I'm sorry. Yes, on 14th of October 1963, my lord, the execution was levied. That is execution, money execution case number, my lord, 448 of 1963. This was, my lord, the immovable properties were attached, my lord, in that proceeding. This also, my lord, I will show your lordship from the exhibits itself. Now, my lord, what happens is, this was, and then, my lord, on 8th of April 1964, that money execution case was dismissed on part satisfaction. Where, my lord, I paid a sum of rupees 400. Now, your lordship will see, my lord, why that was dismissed is not something that your lordship will get from the records.
Then, my lord, your lordship remembers, my lord, that I had to pay him that money in 4 yearly installments. Then in 1964, he files again money execution case number 63 of 1964 for the balance amount of 362.75. This is where, my lord, this is why I request your lordship to, my lord, keep in mind that I was to pay, my lord, in 4 yearly installments. So my right to pay would have accrued, my lord, after one installment was over, or rather my liability to pay rather would have accrued on the second year, my lord, being finished. Am I clear to your lordship, my lord? So one installment in 1962, then 63, then 64, then 65. Now, my lord, what happens is
So
before
whether the terms were complied, the terms of
terms were, my lord, were being complied. It
So
was
that-
not that, my lord, I was not complying.
yes.
Now what happens is behind my back, the Mukherjees, my lord, they filed another execution case and sees the fraud played on court here. Doesn't serve me a copy, my lord, of that execution case, gets an order of, my lord, sale, he buys it himself. My lord, a property of a few bighas, the liability was only rupees 365. He buys it himself in that auction sale. There were no other bidders. Sees the fraud played on court. He buys it himself in the second execution case, and then says, my lord, Mr. Mukherjee is there, my lord. Now, my lord, what he does is he buys it himself, keeps quiet. The record of rights are not touched. He keeps quiet. In 1988, my lord, he sells it to Mr. Mukherjee's client, Mr. Probal Mukherjee's client. Now, very interestingly, my lord, your lordship will find the Mukherjee's, that is Mr. Probal Mukherjee's client, has filed a written statement. Thereafter, my lord, he doesn't appear in court.
The question is, during the pendency of the suit, this transfer was made.
No, later.
98.
Much later. In 1988, my lord, the transfer was made.
No,
This suit was filed just after that.
No, present part of that.
Present suit was filed just after that. Once, my lord, they
came into picture after 1988.
Yes, my lord. The defendant, the purchaser, which is Mr. Probal Mukherjee's client, my lord, the Shorkars, they came into the picture after 1988.
Yes.
So looks to the gap here and sees 3 important dates here. 64, 62, 64, 88. Lord, I'm trying to show your lordship the fraud which is played on court. Now, all these facts are known to the Mukherjees only. The Shorkars have got nothing to do, my lord, with the 62 and 64 degrees. They have not come up and deposed before in this suit. They have filed the written statement. This is why I say, my lord, that the written statement, though filed, was never proved. Mr. Mukherjee, my lord, will have a case saying that I am Order 22, Rule 10. But he has no personal knowledge of what happened, my lord, in 62 and 64. Now I'm sorry.
Yes.
Now the court has gone under, my lord, Order 21, Rule 89, the appellate court. My lord, I will show your lordship, my lord, that is a perverse finding, because the Supreme Court says that if there is fraud played on court, it can be challenged at any given proceeding, collateral proceeding, suit, whatever it is. Even if he, my lord, goes and, my lord, asks for something on the basis of that fraudulent degree, in that proceeding also, my lord, I can challenge, my lord, a degree or rather an order obtained by fraud. My lord, what is the fraud? That is on the face of it. A person is entitled to 300 rupees. He is to get it at a particular point of time in terms of a degree. He doesn't allow that time to, my lord, lapse. He goes to the court, files another execution case, says that it's within 2 years, so I get an order of sale from the court. And then, my lord, he himself only participates in the bid, and he, my lord, purchases the property. My lord, marks it, this is a property which is 3.5 bighas. Every katha would fetch, my lord, and today's world, my lord, it will be much more. But even at that point of time, it would have fetched, my lord, much more than 365 rupees. So this is the fraud on the face of it, which has been, my lord, played on court. And kindly keeps in mind, apart from whatever, my lord, the ponds and trees are being, my lord, cultivated there, or fishery or whatever, my lord, it is also my residential property. My lord, the other very important aspect in the matter is, my lord, apart from the fact that he did not, my lord, appear, he has got it recorded, my lord, in the, my lord, the execution case, that he has got possession from me. My lord, I will show your lordship the admission made by the Shorkars that I am in possession of the property even today. The Shorkars, while giving evidence, have admitted, my lord, that I am in possession of the property till today. But he has gotten it, my lord, your lordship is much aware about what happens in the trial court with the bailiffs, and my lord, I'm not going to open my mouth on that. But look at the fraud which is played on court, saying that they have gotten possession, my lord, from me in execution of that degree of sale. There is only a sale certificate. And then, my lord, the Shorkars admit that I am always in possession. My lord, the lordship remembers the Mukherjees, they filed a written statement and made out a cock and bull story that after, my lord, this degree, I prayed before them to allow me to stay in the property. And, my lord, they granted me license. There is not a single evidence on record to show, my lord, that yes, nothing, no document to show, my lord, that license or tenancy or whatever, my lord, was created in my favor. These are the elements of fraud, my lord, which I will demonstrate before your lordship to show, my lord, that the earlier order which I am challenging in the suit is an outcome of fraud. Order 21, Rule 89 is definitely there. There is no dispute on that. But does that preclude me from filing a suit? Supreme Court says no. I have a right to file a suit. My lord, I'm sorry.
Yes.
The sale certificate, my lord, is issued on 3rd of February 1965. These are all exhibits. 3rd of February 1965.
Yes, in the list it is there.
In the list of dates your lordship will find. And then, my lord, your lordship will find possession of properties delivered to, my lord, Mukhopadhyay's in 1966. Then if it is delivered to the Mukhopadhyay's in 1966, my lord, a fresh, my lord, agreement had to be entered into, my lord, with me, showing that I am a licensee.
That means by virtue of execution, possession is handed over.
Exactly. That's what they said. That's what they said. But now they admit, my lord, that I am in possession. So that fraud was, my lord, played. That fraud was discovered moment, my lord, they transferred the property, my lord, to Mr. Mukherjee's client, the Shorkars. Your lordship knows section 17, my lord, the limitation will run only when the fraud is discovered, not when the fraud, my lord, has actually happened. That is section 17 of the Limitation Act. My lord, I will keep it at that for the moment. I will request Mr. Mukherjee, my lord, to place the written statement of the, my lord, of the Mukherjees before your lordship, my lord, where, my lord, these things will come out, my lord, before your lordship. Whatever is there, my lord, in the my lord, the list of dates.
Page 21.
Yes, page 21. Kindly allows Mr. Mukherjee to place it, my lord, because I am online.
Page 21, my lord, of the compilation, or your lordship, my lord, paper book since the second.
My lord, Mr. Mukherjee, I have given my lord a smaller compilation where I have annexed all these documents together, which I want to rely upon.
This
Mr. Arifin will help you with that.
Spiral bound.
Even the spiral bound will have it.
Right.
Spiral bound will also have the translation. Your lordship doesn't need the translation, my lord. I think Mr. Mukherjee can.
For the other banks, my lord, the vernacular language was problem.
Yes.
But here, yes, that's why, my lord, this.
So shall I go through?
My lord, kindly takes up.
We are not trusting Mr. Mukherjee's translation at all.
No, translation is convenient for all.
Certainly, my lord, certainly. Yeah, on a lighter note, my lord, we are not trusting Mr. Mukherjee's translation, my lord, into. He is more British, my lord, than us.
Yes.
I didn't do that.
So it is convenient not for some, but all.
Yeah, definitely.
Timing your lordship, but don't take the, my lord, the thicker one, my lord, a small compilation, my lord, is being given, my lord, by Mr. Arifin, my lord, not the paper book, my lord. একটা আলাদা করে
ছোট দেয়া ছিল আগের বার।
Yes.
Down.
Is it this one?
Yes, this one. আরেকটা দিয়ে দাও। পাতলাটা দিয়ে দাও। Lord, kindly comes to Lord, page 12 of this, Lord, compilation. না 3 নম্বর তো।
3 নম্বর নয়, আগে 1 নম্বর।
আগে এক একটা দেখা পাচ্ছে।
আগে একটা।
Then Lord kindly comes back, Lord, to
page.
Lord, page 70. 17.
Yes.
Lord, may I place? বাদীর
Paragraph 6, অত 1 to 5 পড়ার দরকার, that's usual.
Paragraph 6. 1 নম্বর বিবাদী এই মোকদ্দমার অনাবশ্যক পক্ষ নালিশি জমিতে তাহার কোনো সত্ত্ব সাব্যস্ত দখল নাই, সে কারণে তদ্বিরুদ্ধে বাদীর এই মোকদ্দমা চলে না। মিসজয়েন্ডার অফ পার্টিস দোষে বাদীর মোকদ্দমা চলে না। বাদীর আর্জির 2, 3, 4 ও 5 দফার উক্তি মিথ্যা ও কাল্পনিক। নালিশি জমি বাদীর নামে গত ওয়েস্ট বেঙ্গল ল্যান্ড রিফর্মস অ্যাক্ট অনুযায়ী রেকর্ড হওয়া, বাদী বাংলাদেশ হইতে এদেশে আসা এবং নালিশি জমি খরিদ করা বা নালিশি 902 দাগের উপর বসতবাটি নির্মাণ করিয়া তাহার সপরিবারে বসবাস করা এবং ফলপ্রসূ বৃক্ষাদি ফল করা গ্রহণ করা এবং 902 দাগের সহিত 923/1826, 923, 909 ও 896 দাগের জমি দাগের জমি একক করিয়া পাওয়া এবং নালিশি ভূমির উপর একটি পুষ্করিণী বিদ্যমান থাকা, তাহাতে মৎস্য ছাড়া ও রক্ষণাবেক্ষণ করা বা নালিশি জমির উপর একটি নলকূপ প্রকৃত করা, তার দ্বারা জল নিশ্চয় করিয়া ফসলাদি উৎপন্ন করা বা তাহা গ্রহণ করিবা ইত্যাদি উক্তি সম্পূর্ণ মিথ্যা ও কল্পনাপ্রসূত। এদশ থাকে প্রকাশ থাকে যে 5টি দাগের জমির কতক অংশে বাদী উপজাত তাই নিজ ধান্য থাকার উক্তি ও বসতবাটির এলাকার মধ্যে
উপজাত চাইনিজ ধন্য
মধ্যে বাদী একটি মুরগির পোল্ট্রি স্থাপন করার উক্তি বা নালিশি জমির বাবদ পশ্চিমবঙ্গ সরকারকে খাজনা দিয়া দাখিলা প্রাপ্ত হওয়ার উক্তি এবং রামচন্দ্র মুখোপাধ্যায়ের পুত্র বাদীর নিকট হইতে টাকা পয়সা লইয়া তাহাদের দাখিলি মোকদ্দমা দায়ের দিত উক্তি সম্পূর্ণ সত্য নহে। আরজির 4র্থ দফার উক্তি আংশিক সত্য বটে। বাদী কথিত নামে মানি
লেন্ডার
জমি মানি লেন্ডার
বাদী কথিত জমি মানি লেন্ডার এর মোকদ্দমার ডিক্রি প্রাপ্ত দিয়া 365 টাকা নিলাম উক্ত খরিদ করিয়া বয়নানামা জারি ক্রমে দখল লইয়া ছিলেন সত্য। পরে উহা 2 নম্বর বিবাদীর নিকট বিক্রয় করিয়া দখল দিয়াছেন সত্য। উক্ত জরাজীর্ণ উক্ত
উক্ত জারির
জারি
জারির মোকদ্দমা
মোকদ্দমার নোটিশ সেল প্রোক্লামেশন যথারীতি আদালতের যোগে জারি হইয়াছিল এবং 1 নম্বর বিবাদী সরজমিনে দখলপ্রাপ্ত হইয়াছিলেন, এই কার্যকলাপের মধ্যে কোনরূপ তঞ্চকতা ছিল না। নালিশি জমিতে বাদীর আদৌ কোনো দখল নাই, সে কারণে অ্যাড ভ্যালিডাম কোর্ট ফি না দেওয়ায় বাদীর মোকদ্দমা চলে না।
Kindly marks this, Lord. They say that I am not in possession.
So any commission was appointed for this possession purpose?
There was a commission. There was a commission. My Lord, your Lordship will find that happening at 24th of April 1988. Lordship sees the list of dates. I'll show your Lordship. There was a commission and there is a report.
Yes.
আমরা প্যারাগ্রাফ 8 প্রকৃত বৃত্তান্ত এই যে এই বিবাদীর পিতা স্বর্গীয় রামচন্দ্র মুখোপাধ্যায় অত্র আদালতে 1962 সালে জারি মোকদ্দমায় ডিগ্রি প্রাপ্ত হইয়া উহা 1964 সালের 63 নম্বর জারি দিয়া আদালতের যাবতীয় প্রসেস যথারীতি জারি করিয়া গত 23/3/66 তারিখে নালিশি জমিতে যথারীতি দখলপ্রাপ্ত হন এবং গভর্নমেন্টের খাজনাদি দিয়া দখলপ্রাপ্ত হইয়াছেন। প্রকাশ থাকে যে পূর্বোক্ত মানি মোকদ্দমা জারিতে বিবাদী থাকেন। উপরোক্ত মানি মোকদ্দমা ও জারি মোকদ্দমা এই মোকদ্দমার বাদীর বিরুদ্ধে পরিচালিত হয়। বাদী তাহা পূর্বাপর সমস্ত বিষয় অবগত ছিলেন ও আছেন। তৎসত্ত্বেও নিতান্ত দুর্লভের বশবর্তী হইয়া এই মিথ্যা মোকদ্দমা করিয়াছেন। পক্ষান্তরে এই বিবাদী নালিশি জমি খরিদের পরে দখল লইয়া কিছুকাল দখল করিয়া 3,500 টাকা পণ গ্রহণে কালুপুর গ্রাম নিবাসী শ্রী সুধীর কুমার সরকারের নিকট নালিশি 2.09
So, Mr. Mukherjee, one second. My Lord, kindly looks to the amount which, my Lord, he has sold. Kindly looks to that amount. The amount on which he has sold, my Lord, these properties to Mr. Mukherjee's client.
35,000.
Yes, and keeps in mind the amount I had to pay him.
No, 35,000 in the year
88. In the year 88. And I had to pay him 300 something odd. In 62.
2.09 শতক জমি বিক্রয় করিয়া তাহাকে নালিশি জমিতে দখল দিয়াছেন। তিনি উক্ত জমি জমাতে যথারীতি দখল করে আছেন। তিনি প্রকৃতপক্ষে বিবাদী হওয়ার উপযুক্ত বটেন। তৎসত্ত্বেও নিঃসত্ত্ব বিবাদীকে অন্যায় মতে পক্ষ করিয়াছেন। বাদী এই মোকদ্দমার কোনো প্রতিকার পাইতে পারেন না। পক্ষান্তরে এই বিবাদী দেওয়ানি কার্যবিধি আইনের 35 ধারার বিধান মতে এক্সাম্পলারি কস্ট পাইতে অধিকারী এবং তাহা তিনি দাবি করেন। বাদীরা মিথ্যা ও হয়রানকর মোকদ্দমা ডিসমিস হইবে এবং বিবাদীতে এক্সাম্পলারি কস্ট পাইবেন। প্রকাশ থাকে যে বাদী এই বিবাদীর পিতার ও এই বিবাদীর নিকট নালিশি বসতবাটিটুকু সাময়িকভাবে বসবাস করিবার জন্য বহু কান্নাকাটি করায় তাহারা বাদীকে অনুমতি সত্ত্বে বসবাস করিতে দিয়াছিলেন। সেই বাদীকে অনুমতি সত্ত্বে বসবাস করিতে দিয়েছিলেন, কিন্তু তিনি উহারই পূর্ব সুযোগ লইয়া আর ওই উক্ত জমির দখল এই বিবাদীর নিকট পরিত্যাগ করেন নাই। This portion has been dealt with by the learned trial judge also, that the house property which is situated over the suit property in question, it has, the case made out in the written statement is that his father, my father, was given on license, and even
subsequent event, that is
that as per the defendant's case, but I am still in possession at the time when the written statement
licensee cannot be in possession.
Possession is being they have stated that they are not.
Actually, they gave you license, means possession retains with the licensor.
Yes.
That's the yes, not symbolic that. But not the physical possession is with my father as per the plaintiff.
Milord, that 1 second, Mr. Mukherjee, Milord, there are two lines here which are very important. They say in execution they had taken Milord possession.
Yes.
Kindly appreciate they had taken possession and then allowed me to stay.
Yes,
So
they have
I was driven out and then I was put back in. There is a difference, Milord, between the two. It is not that I have retained possession. They are saying, Milord, that I had given them back possession. That is the first line. Kindly have Mr. Mukherjee reads that paragraph.
lawful possession through the court of law.
Yes,
and
Milord.
thereafter,
Thereafter, I was put back. My lord.
Yes. So, Milord, it's
So
the
they had to prove that license was granted.
possession admitted.
That I'm in possession today, that's admitted. But that I had given up possession is not admitted.
Yes.
I am in possession is admitted. That I had given up possession, my lord, and they had taken possession is not admitted.
That means
That is where the fraud is.
Yes, that means possession was taken and license was issued.
Yes.
That is not proved.
Not proved at all.
দাদা এবার কি ডিফারেন্ট নাম্বার 3 এরটা পড়বো?
Yes, yes, yes.
My lord, kindly takes up, Lord, the comes back, my lord, it's the defendant number 3's, my lord, written statement is annexed earlier, that is page 12 of my lord's that compilation. May I read from paragraph number 6?
Yes.
Has your lordship got it?
Yes.
নালিশি জমি বাদীর খরিদা হাস সত্ত্বাধিকৃত জমি সম্পত্তি হওয়া এলার অ্যাক্ট সেটেলমেন্টে নালিশি জমি বাদীর নামে রেকর্ড হইয়া উহা অদ্যাপি অপরিবর্তিত থাকা বাদী নালিশি সমস্ত দাগের জমি একজোট করিয়া দখল করা 902 দাগের জমি ব্যতীত অন্য জমিগুলির উপর বাদীর কোটিয়ার্ড বা এটা কি লিখেছে কোটিয়ার্ড বা কাটিলেজ বিদ্যমান থাকা ওই সকল জমিতে বাদীর উপজাত বহু আম গাছ কাঁঠাল গাছ নারকেল গাছ সুপারি গাছ ইত্যাদি ফলপ্রসূ বৃক্ষাদি বিদ্যমান থাকা ফলপ্রসূ বৃক্ষাদির ফলাদি বা উপসত্ত্বাদি বাদী গ্রহণ করিয়া আসা পুষ্করণীতে বাদীর মৎস্য ছাড়া ও সংরক্ষণ বা গ্রহণ করা নালিশি জমির উপর বাদীর একটি বিদ্যুৎ চালিত শ্যালো টিউবওয়েল বিদ্যমান থাকা বাদীর উহার সাহায্যে জল উঠাইয়া নালিশি জমিতে জল নিশ্চয় করিবার ফসলাদি উৎপাদন ও গ্রহণ করিয়া থাকা নালিশি দাগের সময় আরজির বার্ষিক 5টি দাগের জমিতে কতক কতক অংশে বাদীর উপজাত আদৌ কোনো ধান্য বিদ্যমান থাকা বা বাদী উহা কাটিয়া লইতে থাকা বাদী কোনো পোল্ট্রির করা বাদী সকলের সরকার সেরেস্তায় করাদি দিয়া দাখিল গ্রহণ করা আশা সমস্ত স্বর্গত রামচন্দ্র মুখোপাধ্যায়ের মহাশয় বা তাহার পুত্র 1 নম্বর বিবাদী বাদীর নিকট হইতে পাওনা নগদে বুঝিয়া প্রাপ্ত তাহার মোকদ্দমা ছাড়িয়া দেয়া প্রকাশ বা প্রচার করিতে আরম্ভ করা 1 ও 2 নম্বর বিবাদীর নিকট হইতে নালিশি জমি সম্পর্কে এই বিবাদী কোনো দখল আদি হাসিল করিয়া লইয়াছেন বলিয়া আদৌ কখনো নালিশি জমি বা বাদীর বসতবাটি জোরপূর্বক দখল করিয়া লইবেন বলিয়া কখনো প্রচার করা বাদীর তথাকথিত ডিক্রি জারি বা নিলামের বিষয় কিছুমাত্র অবগত না থাকা বা এই সম্পর্কে কোনো নোটিশ বা পাওয়ানাদি বাদীর উপর কদাপি জারি না হওয়া তথাকথিত ডিগ্রি জারি বা তৎমূল্যে নালিশি জমি ক্রয় নির্মাণ 1 নম্বর বিবাদী ও তাহার পিতা আদালতের প্রসেস সার্ভারকে অবৈধ উপায়ে বশীভূত করা বা ওই ডিগ্রি জারি বা নিষ্কর্ম সম্পর্কে নোটিশে পাওনাদি পাওনাদির পরে কি লেখা আছে বলতো পাওনাদি সত্য সম্পর্কে গোপন করা বা মিথ্যা রিটার্ন বা অর পয়েন্ট দেওয়ার বা আদালতকে ভ্রমাত্মক কোনো বেআইনি ভুয়ো ভয়েড তঞ্চকি নিলাম হাসিল করা লওয়া স্বর্গত রামচন্দ্রকে কোনোদিন কোনো প্রকারে নালিশি জমিতে দখলপ্রাপ্ত না হওয়া বা কাগজে কলমে জারির কার্য হাসিল করিয়া লইয়া নালিশি জমিতে কখনোই কোনো প্রকার দাখিল পরোয়ানা জারি না হওয়া, নালিশির জমির মূল্য 20 বছর পূর্বের প্রসূত বিঘা 10,000 টাকার কম না থাকা, উহ টাকায় নালিশি জমি সম্পত্তি নিলাম বিক্রয় হওয়া, দেখি আছে বলতো, শোয়িং টু দি হিউম্যান কনসান্স,
Shocking to human conscience.
হিউম্যান কনসাস হওয়া, বসতবাটি নিলাম না, ঠিক আছে, নিলাম বিক্রয় তথাকথিত নিলাম বেআইনি ভুয়ো তঞ্চকীয় নাল অ্যান্ড ভয়েড ও উইদাউট জুরিসডিকশন হওয়া, তথাকথিত নিলামের দ্বারা নালিশি জমিতে বাদীর সত্ত্ব সম্পর্কে বিন্দুমাত্র ক্ষুণ্ণ না হওয়া, এই বিবাদীর কোনো কার্যের দ্বারা বাদীর কোনো সত্ত্ব দখল মেঘচ্ছন্ন হওয়া, বাদীর প্রসিত প্রতিকার পাইতে অধিকারী হওয়া, ইংরাজি 7-8-88 তারিখ হইতে নালিশির কারণ উদ্ভব হওয়া ইত্যাদি আর্জির উক্তি সম্পূর্ণ মিথ্যা ও দুরভিসন্ধিমূলক, বাদী প্রার্থিত কি আদৌ কোনো প্রতিকার পাইতে পারেন না। These are the Milord denial part. Now paragraph 7. প্রকৃত বৃত্তান্ত এই যে প্রকাশ থাকে বনগ্রাম মুন্সিফি আদালতে 1 নম্বর বিবাদীর পিতা রামচন্দ্র মুখোপাধ্যায় মহাশয় বাদীর বিরুদ্ধে 1962 সালে টাকা আদায়ের নিমিত্ত 59 নম্বর মানি স্যুট এর মোকদ্দমা দায়ের করিয়াছিলেন। উক্ত মানি মোকদ্দমা উভয় পক্ষের মধ্যে 16 ডিগ্রি হলে 1 নম্বর বিবাদীর পিতা বাদীর বিরুদ্ধে টাকা আদায়ের ডিক্রি প্রাপ্ত হইয়াছিলেন। তদন্তর বাদী এই ডিক্রির টাকা আদায় না দেওয়ার কারণে 1 নম্বর বিবাদীর পিতা ওই মানি ডিক্রি অত্র আদালতে 1964 সালের 63 নম্বর মানি এক্সিকিউশন কেস দায়ের করেন এবং উক্ত ডিক্রি স্ট্রোক জারি মূলে গত ইংরাজি 1964 সালের 10ই নভেম্বর তারিখে আদালতের প্রকাশ্য নিলামে ডিক্রিদার বহুত স্বর্গীয় রামচন্দ্র মুখোপাধ্যায় মহাশয় নালিশি জমি সম্পত্তি নিজ ডিক্রিদার স্বরূপে খরিদ করিয়া লয়েন। তৎপর স্বর্গত রামচন্দ্র মুখোপাধ্যায় মহাশয় পূর্বোক্ত নিলামের বয়নানামা তথা সেল সার্টিফিকেট জারি দ্বারা গত ইংরাজি 23/3/66 তারিখে আদালত যোগে নালিশি জমি সম্পত্তিতে যথারীতি দখল প্রাপ্ত হয়েন। স্বর্গত রামচন্দ্র মুখোপাধ্যায় মহাশয় ও তাহার পরলোকান্তে তাহার পুত্র যথাক্রমে 1 ও 2 নম্বর বিবাদীগণ নালিশি জমি সম্পত্তিতে যথারীতি খাসে সত্ত্ববান ও দখলিকার থাকেন। প্রকাশ থাকে যে বাদী ওই নিলাম বিক্রয় হইয়া যাইবার পর স্বর্গত রামচন্দ্র মুখোপাধ্যায় মহাশয় ও তাহার
Another thing, the record of rights at that point of time was in whose name? Name of the plaintiff or the defendant?
My name. In my name.
It was in your name.
Yes, my lord.
And those land rent and all these were paid
Everything in my name.
It was also in your name.
Absolutely.
And in your custody, those receipts.
Absolutely, my lord.
স্বর্গত রামচন্দ্র মুখোপাধ্যায় মহাশয় তাহার পরলোকান্তে তাহার পুত্র স্ত্রী যথাক্রমে 1 ও 2 নম্বর বিবাদীগণ নালিশি জমি সম্পত্তিতে যথারীতি খাস সত্ত্ববান ও দখলিকার থাকেন। প্রকাশ থাকে যে বাদী ওই নিলাম কর্ম বিক্রয় হইয়া যাইবার পর স্বর্গত রামচন্দ্র মুখোপাধ্যায় মহাশয় ও তাহার পরলোকান্তে 1 নম্বর বিবাদীর হাতে ধরিয়া কান্নাকাটি করিয়া নালিশি জমি সম্পত্তির মধ্যে শুধুমাত্র ওই বসত বাটিটুকু সাময়িকভাবে দখল করিবার অনুমতি প্রার্থনা করেন এবং যথাক্রমে তাহার ভ্রাময়িকভাবে ওই বসতবাটিটুকুতে মাত্র বাদীকে থাকিবার অনুমতি প্রদান করিয়াছিলেন। তদ্দতীত নালিশির উপর সম্পত্তি সমগ্র আহ, স্বর্গত রামচন্দ্র মহাশয় ও তাহার পরলোকান্তে 1 নম্বর বিবাদী যথারীতি
Mr.
দখল
Mukherjee, just 1 minute. Milord, if your lordship wants to see the record of rights, it's in that compilation at page 39. Just to keep your lordship. Port.
হ্যাঁ, তদ্দতীয় নালিশির উপর সম্পত্তি সমগ্র স্বর্গত রামচন্দ্র মহাশয়।
Yes, it is there. This documents regarding
Yes.
payment of rent.
Yes.
Yes, sir.
Okay, then you proceed.
Yes. Sir. Even the record of rights, payment of rent, everything.
এবং যথাক্রমে তাহার ভ্রাময়িকভাবে ওই বসতবাটিতে মাত্র বাদীকে থাকিবার অনুমতি প্রদান করিয়াছিলেন। তদ্ব্যতীত নালিশির উপর সম্পত্তি সমগ্র স্বর্গত রামচন্দ্র মহাশয় ও তাহার পরলোকান্তে 1 নম্বর বিবাদী যথারীতি দখল ভোগ করিয়া আসিতেছেন। বাদী একজন অতি ধূর্ত শয়তান বিশ্বাসঘাতক লোক হইতেছেন। তিনি সম্পূর্ণ দুর্লোভের বশবর্তী হইয়া 1 নম্বর বিবাদীর উপর উপেক্ষা করিয়া অদ্যবধি ওই বসতবাটিটুকু দখল পরিত্যাগ করেন নাই। 1 নম্বর বিবাদী একজন অতি শান্তিপ্রিয় নিরীহ প্রকৃতির লোক হইতেছেন। তিনি আদৌ কোনো ঝুট ঝামেলা বা মামলা মোকদ্দমা জড়িত হইতে ইচ্ছুক নহেন। তাহা হেতুক এইরূপে পরিস্থিতিতে নালিশির অন্যান্য খাস জমি সম্মত বসতবাটির জমিভুক্ত তৎকালীন ন্যায্য মূল্যে গত ইংরাজি 4/5/1988 তারিখে সম্পাদিত ও রেজিস্ট্রিকৃত খাস কোবালা দলিল মূলে এই বিবাদীর নিকট হইতে হস্তান্তর করিয়া দিয়াছেন এবং তদ্বতী বসতবাটিটুকু বাদে সমগ্র নালিশি জমি সম্পত্তি এই বিবাদীর যথারীতি খাস সত্ত্ববান ও দখলকার আছেন। তৎপূর্ব 1 নম্বর বিবাদী এই বিবাদীর বরাবর নালিশি জমি সম্পত্তি সম্পর্কে বায়নাপত্র দলিল সহি সম্পাদন ও রেজিস্ট্রি করিয়া তাহাকে পূর্বোক্ত রূপে দখল প্রদান করিয়াছিলেন। এই বিবাদী ওই জমি সম্পত্তি বায়না করিয়া লইবার পর ও বাদীকে নালিশি বসতবাটির জমির দখলে পরিত্যাগ করিবার জন্য বহু অনুরোধ সাধনা করিয়াছেন, কিন্তু তৎসত্ত্বেও বাদী এই বসতবাটির জমি দখল পরিত্যাগ না করায় এই বাদীর বিরুদ্ধে উচ্ছেদের মোকদ্দমা দায়ের করিবেন বলিয়া প্রকাশ করিতে থাকায় ধূর্ত ও শয়তান বাদী অগ্রসূচি হইয়া আগাগোড়া মিথ্যা উক্তি করিয়া এই মিথ্যা দাবির মোকদ্দমা স্থাপিত করিয়াছেন ও অকারণ অযথা এই বিবাদীকে হয়রান ও খরচান্ত করিতেছেন। নালিশি কোনো জমি সম্পত্তিতেই বাদীর আদৌ কোনো সত্ত্বাধিকার নাই বা থাকিতে পারে না এবং তিনি এই নালিশি বসতবাটির জমিটুকু ব্যতীত অন্য কোনো নালিশি জমিতে আদৌ দখলিকার নাই এবং থাকিতে পারেন না। প্রকাশ থাকে যে বিবাদী পরলোক গমন 2 নম্বর বিবাদী পরলোক গমন করিয়াছেন। উপরিউক্ত সমস্ত অবস্থা মতে বাদীর উক্ত মিথ্যা অন্যায় ও অবৈধ দাবির মোকদ্দমা ডিসমিস হইয়া এই বাদীর খরচ পাইবার অধিকারী।
Yes.
PW1.
এটা তো এই ব্রাঞ্চে পাবে না।
না, spiral binding. Mr. Mukherjee, there is an additional written statement you would want to place that?
Yes, that is page 26 of the Thika compilation. That is that one.
Milord, because we had amended our plaint, that is why, Milord, they had filed an additional written statement. That is why, Milord, your lordship looks into it, though it might not be very germane. I'll be very frank, because this will more lead to something which I don't think I'm going to press about adverse possession. But that is something different.
Question is, you know the scope of second appeal also.
Absolutely, Milord. Absolutely. I'll stay within fraud. And how, my lord, the courts have not seen the evidence which is on record and not even discussed on fraud and how fraud unravels everything, my lord. They have not even gone into that. They've gone into limitation and also, my lord, Order 21, Rule 89. I'll show your lordship that. That's where, my lord, I'll come in with respect to law.
It's better to read the
Type
English.
copy, is there any type copy?
Type copy is below 26.
Only
There
can
is
you
a translated version. It's better.
let's go through this one?
Yes, yes, that will
There
be
is a
better.
translated version. You can read that.
This
Handwritten.
no type copy.
It's a
Page
type
26, capital M. Page 26, capital
Just
M.
turns over the page, my lord. Just turns over the page. Your lordship will find the translated copy.
It's the translated
Additional
one.
written statement.
Yes.
Lord, may I read, Lord, from paragraph 3? The incident and the information which has been recorded by the amendment of the plaint long after the filing of the plaint, although so-called particulars being in existence and the application for amendment and the plaint being amended as per the application. But kindly turn below 2 pages.
27A.
Yes. Amended as per the application, this amendment is absolutely illegal and void, and the proof relating to the same is being inadmissible. The relief which the plaintiff has prayed in this para of the plaint by amendment of plaint is being barred by limitation, and the execution case number 63 of 1964 before this court has been disposed of on 13th of January 1965 regarding the self-same confirmation. This regarding the self confirmation of it. Shell confirmation on, yes, my lord, on the prayer for setting aside the order after 28 years, it is not cannot be entertained. Regarding attachment, the statement that the plaintiff has made in this plaint is against law and is so fraudulent act. The plaintiff having no basis, only for delaying the case, have got amendment of plaint. The original money suit by attachment before judgment being made further attachment is not required in execution of decree. All these statements made in item number 4 of the plaint by the plaintiff by way of amendment of the plaint are self-contradictory and false as stated in the said item in suit number 60 of 1962. Let Ramchandra Mukhopadhyay and his son, defendant number 1, after receiving the amount claimed from the plaintiff to their satisfaction and giving up this suit, all this statement is false. In this suit, the plaintiff having made settlement with Ramchandra Mukhopadhyay and getting rebate of rupees 150, the plaintiff promising to pay rupees 750, marks not kindly this portion, in 4 years by annual installment submitted terms of settlement, and accordingly the terms of settlement being treated as a part of the decree. The decree was published, the plaintiff having not paid the said amount in the present suit. The court put the property mentioned in the schedule on auction, and decree holder Ramchandra Mukhopadhyay purchased the suit property in the said auction. And the said auction was confirmed by the court on 13th of January 1965. As stated in the amended plaint of the plaintiff, the money execution case being dismissed on part satisfaction by way of amicable settlement, and the disputed land being not attached, and after the death of Ramchandra Mukhopadhyay, defendant number 1 making any demand for the same with interest, and the plaintiff making payment of rupees 950 or any other amount with interest to the defendant number 1, and for this reason the said decree or execution case not remaining in existence, all these statements are false. Ramchandra Mukhopadhyay called the decree to be issued against the plaintiff by way of settlement, and he, by purchasing the property mentioned in the schedule on auction, having set off the amount, the execution of decree was disposed of, and the auction purchased was confirmed by the court on 13th January 1965. All the statement made by way of amendment in item number 4 of the plaint are on the basis of misconception of law and fact. The statement that the money execution case number 448 of 1963 mentioned in the amended plaint of the plaintiff being dismissed on part satisfaction and the disputed and being not under attachment, and after the death of Ramchandra Mukhopadhyay, the remaining amount of decretal amount being claimed by the defendant number 1 and a sum of rupees 950 with interest remaining due, and by paying the same to defendant number 1 and there being no existence of the said decree or execution case, all these statements are false. Ramchandra Mukhopadhyay have started execution of the decree received by way of settlement against the plaintiff, and he, by purchasing the property mentioned in the schedule in auction and having set off the amount for decretal of the auction amount, the execution of decree was disposed of, and the auction purchased laws purchase deed হবে মনে হয়, confirmed on auction purchase was confirmed on, oh sorry,
Was confirmed on
yes, was
13th
confirmed on 13th of January 1965. All the statement made by way of amendment of plain past are being misconception of law and fact, even if any execution of decree is dismissed on part satisfaction for realization of remaining sum, execution of the decree is lawful. There being attachment of judgment in the original suit and there being no attachment in the execution of decree, the execution case is not at all unlawful, and the said auction there being no other attachment in execution of decree. The money execution case number 63 of 1964 is not illegal in any way at all for the amount receivable in the money execution case number 59 of 1962. Ramchandra Mukhopadhyay, without making further attachment, had lawful right to put the case on execution of decree until the payment is made. The auction which was held in execution of the said decree, the same was lawful and by way of purchase in the said auction. The Ramchandra Mukhopadhyay has got good right and title of the money execution case number 63 of 1964 is not at all unlawful and void. In the said execution of decree, Ramchandra Mukhopadhyay has got good right and title on the disputed land, and by way of his inheritance, defendant number 1 has got good title and possession, and by way of purchase from him and the defendant also got good title in the disputed property. After the auction, the sale certificate which has been issued by the court and the document relating to the execution of the decree being false and illegal and void. All these statements in the plaint is false. All the statement that defendant number 1 between any legal act without the knowledge of the plaintiff and the defendant number
But
3.
I think there is something wrong there. If your lordship sees the statement, it says after the auction, the same certificate which has been issued by the court and the document relating to the execution of the said decree being false and illegal.
So
There's a problem, my lord, in translation there. That is exactly why I didn't want the translated thing to be
that
read.
is 29
Yes, my lord. 29.
in the Bengali version.
In the Bengali version goes back, my lord. But the handwriting is extremely, my lord. Mr. Probal Mukherjee would be able to help us on this because the translation was done by them.
দাদা বাংলাটাই পড়ে দিচ্ছি তাহলে।
হ্যাঁ হ্যাঁ
Page 29, Bengali version.
Yes, my lord, 29.
4 of the amended written statement সংক্রান্ত কোনো কাগজপত্র
Now, which paragraph you
but
repeat?
it's not
Well, the paragraph is, it's
Because after 29 is 29A,
paragraph
thereafter
7.
29B.
Yes, my lord, paragraph 7. That's paragraph 7.
Paragraph?
That your lordship will find from page 28.
28, yes, my lord.
Page 28.
Page
Yes, my lord.
28, it's a continuation of paragraph 7.
It is better you place 28. It is better you place the entire paragraph 7 for the sake of continuity.
Okay, page 28.
হ্যাঁ একটু পড়াটা শক্ত হচ্ছে বাট
Yes, the বাড়ির সহস্র
বাদির
বাদির
বাদীর পরেরটা আমি বুঝতে পারছি
আরজি আরজি 4 দফার
চতুর্থ অনুচ্ছেদের
আরজির 4 দফার মিসকনসেপশন অ্যান্ড ল অন মানে বেসিক্যালি ডিনায়াল কোন
ল
ল অ্যান্ড ফ্যাক্টস হইতে মিসকনসেপশন অফ ল অ্যান্ড ফ্যাক্টস হইতেছে
কোনো জারি করা
কোনো জমা করা ফ্যাক্ট স্যাটিসফ্যাকশন এ ডিসমিসাল হইলেও জমি
প্রাপ্ত টাকা আদায়ের জন্য পুনরায় ডিক্রি জারি করা আইনসহত কোনো মূল মোকদ্দমায় অ্যাটাচমেন্ট বিফোর জাজমেন্ট হওয়া উক্তি জারিতে
অ্যাটাচমেন্ট বিফোর জাজমেন্ট
লাগে না 63 অফ 1964 নম্বর জারির মোকদ্দমা আদৌ কোনরূপ বেআইনি হয় নাই 59 অফ 1962 নম্বর মোকদ্দমার পত্রেও প্রাপ্ত টাকার জন্য রামচন্দ্র মুখোপাধ্যায় তার ফার্দার অ্যাটাচমেন্ট করিতে ডিগ্রি না থাকার পলাতক যতবার খুশি ডিগ্রির জন্য দেওয়ার
they want to say that if the degree is not satisfied they can put in the degree as many times as they want to. This is what they want to say in that paragraph.
এই উক্তি যে নালিশি জমির তাহা আছে এই নয় খরিদের দ্বারা নালিশি সম্পত্তিতে রামচন্দ্র মুখোপাধ্যায় ডিগ্রি
রামচন্দ্র মুখোপাধ্যায়ের দিয়া হয়েছিল 63/64 এর জারি এর void নহে 63 of 64 এর বাড়ি void নহে
আদৌ বেআইনি বা ভয়েড
নহে
জারিতে নিলাম খরিদ মূলে নালিশি জমিতে রামচন্দ্র মুখোপাধ্যায় সত্ত্বের
ঘরের
সত্য হয়েছে এবং তাহার উপরিউক্ত সূত্রে 1 নম্বর ও তার খরিদা সূত্রে হবে তাহার খরিদা সূত্রে 1 নম্বর বিবাদী সত্য সাব্যস্ত দখলের উদ্ভব হইয়াছিল তাহার সত্যীয় দখল সূত্রে
না এটা ঠিক করে দেখতে হবে
জায়গাটা পড়া যাচ্ছে
Milord, maybe Milord come back on the next day because we'll have to Milord settle this.
This portion of 29
this portion is a little difficult because I say Milord what they want to say is that the second execution is not void, but they have made certain statements with respect to that. Milord, let us understand the entire thing. Come back on the next day whenever your lordship please, next week or even tomorrow.
Record an order. Learned advocates for the parties are present. Learned advocate for the appellant submits but could not conclude the submissions. Let this matter appear. ইয়েটা কবে দেখুন তো ওই আগের কেসটা কখন রেখেছি? দুটোর সময়। হ্যাঁ, আগেরটা 11th-এ 2 PM, 11th-এ দুটোর সময়। 10 তারিখে কোনো দুটোই ফিক্স আছে? 10 তারিখে? হ্যাঁ, না দুটোই? 10 তারিখে দুটোই ফিক্সড আছে?
At 3, my lord.
আচ্ছা, 10/12/2025 at 3 PM.
Grateful, my lord.
হুম।
এই দেখেছিস?
এই কথাটা নিয়ে।
হ্যাঁ দিয়ে দিচ্ছি এই নামগুলো দিয়ে দিচ্ছি।
কালকে যেটা যেটা বলে দিয়েছে, ঠিক আছে।
I'm grateful.
Grateful.
एक दिलम ना हम दिस एक लिखित क्या लिखছে ঠিক আছে ওকে ঠিক আছে মইনুল
অ্যাপিয়ারেন্সটা দেবেন, অ্যাপিয়ারেন্সটা